Yeah. Well, this matter was listed on March, during the March matter. And retirement period already has been expired. Pensionary benefit matter. They will listed on 24th matter. For admission matter.
24 this month.
Yes, madam.
This month will not be possible, Mr. Counsel. We'll have it on,
Some urgency, my lord.
I understand.
Family pension matter.
Okay, you give a date in the month of September. Just consult, just a minute. It's August. We'll have it on 14th,
14th September.
14th September. Yes.
May I please, your lordship, I beg to mention regarding listing of two matters, lordship, on 26th of August. These are MAC appeal cases and they have been pending since long, lordship. One matter is of 2016 and one matter is of 2019.
Okay, this also will have it on 14th.
All right.
May please, your lordship.
Yes.
Beg to mention item number 6 of today's list, lordship.
See.
6. With the consent of the other side, I beg to mention that I have to file my affidavit, which is for vetting, lordship. 1 week time may be allowed. Instruction has already come. And the affidavit is for vetting.
You have informed the other side?
And the other side is your lord.
I'm for the petition.
Yes. Any objection? Your good name, please.
Kotoki.
On the prayer of Miss M. Kotoki, learned studying counsel,
And
H and Betty.
Children Veterinary Department.
H and Betty. Matter stands adjourned for a week to enable her to file affidavit in the possession of the department. List again after 2 weeks. Statements with, we'll have it on 14 only, list on 14.
Bless.
May I please, your lordship? Lordship,
Yes.
with regard to item number 26 to 28, your lordship. Lordship, those were all part-heard matters, but on the last date, lordship was pleased to release those matters for
Yes.
part-heard. However, the method again has been listed,
Hmm.
though it is bench three, lordship is taking bench three.
Hmm.
The matter pertains to bench two, your lordship.
Bench 2.
Yes, lordship. It's a education matter, your lordship.
Oh. Okay, so, your good name, please?
DJ Das, lordship. I am appearing for the respondent, your lordship. I have informed the petitioner, your lordship. I have informed Mr. A. Chamua, lordship.
Mr. DJ Das, learned counsel, appearing for the respondent number 4. In WPC number
And WPC now 4903 of 2023.
4903 of 2023 submits that the matter pertains to a bench 2. Stop accordingly registry to verify and list matter before the appropriate bench.
Much.
Oh, please, your lordship. I'd like to mention item number 11. The additional advocate general, Mr. Senior Advocate P.N. Goswami will appear in this matter.
Which one?
Item number 11, my lord. We have filed our affidavit in oppositions. Item number 11,
11.
my lord. Petitioners, I've informed the petitioner as well, my lord.
Okay,
Matter may be fixed on another date, my lord. Maybe next week.
who will appear? You are mentioning on behalf of
The respondents, my lord. Transport department,
Transport
my
Department.
lord. Taken consent on the petitioners, my lord.
Who is going to appear?
He is appearing for the petitioner. P.N. Goswami, my lord. Senior Advocate, Mr. P.N. Goswami.
On the request made on behalf of Mr. P.N. Goswami.
P.N. Goswami.
Learned additional AG
Additional.
will be appearing for the transport respondent Transport Department. Matter stands adjourned. You want a date?
Yes, my lord. 2nd September, my lord.
Okay, to be listed again on when to be listed again on 2nd September.
May I please, lordship. My lord, today, item number 19. Under MSc appeal.
Just a minute, 2nd September as paid for.
My lord, item number 19. For
19.
regarding MSc appeal. So my lord, my friend is here, appellant. So there is another 3 analogous cases. So maybe listed along with these cases. I'm giving the list.
You are for the appellant?
No, I'm
I'm
the
for the appellant,
respondent
Your
number one.
Respondent number,
Respondent insurance company.
respondent number,
Respondent number 1. My colleague is,
you are A. Ahmed,
no, I'm RC Paul.
but your name is not there.
My name is there, my lord. Item number 19.
Oh, R.C. Paul, okay.
So, my lord, I'm giving the list, another 3 cases, analogous cases, may be listed together on the 10th of September.
Why, they are all arising out of the same accident?
Same accident.
Same accident.
Same accident.
Claimants are different.
Claimants are different. There are some injured, some dismissed, poor amount. That is their allegation.
Okay, Mr. R.C. Paul, learned counsel for respondent number 1, submits that there are 3 other analogous matter.
I'm giving the list, my lord.
Just a minute, 3 other analogous matters. And therefore, they may be listed along with the present case for consideration. So he submits that all the 3 appeals arise out of the same accident. And
4
therefore, all the 4 appeals,
And
all the 4 appeals are out of the same accident, and therefore it will be appropriate to consider the entire, all the 4 cases together.
fixed on 10th of,
What are the case numbers?
case number, my lord, 303/16, 307/16, and 243/17, along with this case, 64/7.
He submits that the analogous matters are MSC appeal number 303 of 2016, 307 of 2016, and 243 of 2017.
My lord. On 10th of September.
Wait just a minute, 10th, we don't know what is
If,
the position. There are already so many matters fixed on that day.
and 22nd of September, my lord.
It will be too late, your lordship. May it fix on 2nd of September, 2nd September.
2nd September.
What too late? This matter is pending since 2016.
Yes.
Yes.
Nobody has taken steps to have an early hearing.
My lord,
Lordship,
One or
may it
2
fix
weeks will
on
not make
2nd
any
of
difference.
September.
1 2
Lordship
weeks
may-
will not make any difference.
my lord. My
2nd
lord, maybe fixed on
2nd September.
2nd of September. 2nd of September, Wednesday, will be difficult, my lord. 3rd of September. If, I mean,
September.
Tuesday, Thursday.
Okay, we have about.
3rd of September.
And let's wait for list this matter along with insurance in 3/9/2026.
Much obliged.
My lord, I beg to mention a case for listing in admission column, my lord. It pertains for departmental proceeding. A stay is going on, my lord. Matter may vote take it.
Last listed
Last listed on 17th November 2025, my lord.
very first.
31st. Obliged.
May it please our lordship, I beg to mention one WPC for listing,
When was it last listed?
29/5.
Okay, what listing for what? Admission.
Orders.
Notice. We'll have that on 14th of September, okay?
Obliged.
Yes.
My lord, I beg to mention for listing on WPC, my lord. I have filed today, my lord. My lord, matter is urgent because it's related to the transfer of the petitioner, my lord. Transfer order was issued on 18/8/2026. And formality has to be completed within 24/8/2026, my lord. And within 1 year, my lord, 3 consecutive transfer, my lord, which is against the, my lord, guideline. My lord. For tomorrow, my lord.
When did you file?
Today, my lord.
Today only you filed and you want it tomorrow.
Madam, within 24, it is stated that within 24, handing over and taking of the charge has to be.
Okay, tomorrow.
Obliged.
Yes.
Thank you.
Yes, what is this?
That's the instruction, Lordship.
You tell me, you sum up the instruction. I have no time to read all this.
Yes, Lordship, what happened, Lordship, in this case, as per the requisition received from the Director of Industries and Commerce, Department of Industries and
Hmm.
Commerce, FPSC has issued an advertisement, Lordship, into an advertisement. In that advertisement, Lordship, was issued as per the 1997 rule, Lordship. Wherein, Lordship, this process of 11 posts is under the direct recruitment.
Hmm. Yes.
And for the direct recruitment, Lordship, one has to possess the experience of 8 years minimum and in the 5 years in the cadre of Assistant Director of Cottage Industries and above.
Hmm.
The petitioner who has joined in the service as the Assistant Director of Cottage Industry in the year 2024, they are not eligible to compete in this direct recruitment post.
They are promotees.
Yes, Lordship.
They are promotees.
They were appointed as the Assistant Director of Cottage Industries only in the year 2024. So minimum requirement of experience criteria, they have not fulfilled also. If they are competing that functional manager and other post, Lordship, the promotional avenue is still open for them, Lordship. So they have no locus in to fight this petition, present petition, blocking the post for mean for direct recruitment. This is the sum and substance of my.
The one thing you show me, you tell me,
Lordship.
this advertisement,
Yes, Lordship. And advertisement was issued in 2025.
please listen,
Sorry, Lordship.
page 74,
Lordship.
turn the page.
Lordship.
Number 7, experience.
Lordship.
Now, 8 years, 5 years, all those things are there.
Lordship.
Now, what about this? Its equivalent rank, besides that, drawing same pay scale, which should be not less than the term as per the Assam Service Division of Pay Rules 2017,
Yes, Lordship.
as under.
Yes.
So, this is not there in the rules.
Yes, there is a rule, Lordship.
Where? Where is it? Where is it available in the rules?
Lordship. I'm. Lordship, page 97.
'97.
Page 97. Lordship, sorry, Lordship. Prior to that, 89, Lordship, may kindly be seen, Lordship. Page 89.
Yes.
Lordship, rule 8, Lordship, academic qualification and the experiences. Lordship, got it?
Hmm.
The minimum academic qualification for a candidate of direct recruitment shall be as prescribed by the government from time to time. The qualification experience as on date of commencement of this rule are given in schedule 2. That schedule 2 page, Lordship, 97. Lordship, that was the rule at the time of commencement of the rule, Lordship. The page, Lordship, 97, schedule 2. Qualification. For direct recruitment to the post of cadre of Deputy Director, Industries and Functional Manager, Project Manager, Assistant Director of Industries, and its equivalent post, Superintendent of Engineering, and so and so. A candidate must have at least bachelor degree in any branch of engineering or the arts, science, or commerce of a industries or any other institution in India or abroad recognized by the government
for the purpose of minimum second, the experience loss is important. For the post of deputy director of industries and the equivalent post, a candidate must hold responsible and senior position in the government department, government undertaking for at least 10 years, of which 5 years must have been in the rank of assistant director of industries and its equivalent post. It was later on amended that 10 years has been replaced by 8 years, Lordship, by the subsequent notification, Lordship. Lordship would find that that's page 108, 102.
Yes.
Lordship got it. The experience for the post of deputy director of industries and its equivalent post, a candidate must hold responsible and senior position in the government department, government undertaking, at least 8 years of which 5 years must have been in the rank not below the assistant director of so and so. Such the word used, not below the assistant director of industries and assistant director of industries. For the post of assistant director of industries and equivalent post, a candidate must be so and so, Lordship. Now, Lordship, in pursuance to that prescription, page 74, Lordship.
Correct, that's what I pointed out. Scale of pay not less than term of Assam Service Revision of Pay Rules 2017.
Yes, now,
Pay
Lordship.
band 4, grade pay 13,900.
Sir,
Why have you given all this?
Why,
details?
what the law prescribed that not below the rank of assistant director of
Not below the rank.
so.
The
For
pay scale can differ also, you see, same rank,
No.
pay may differ also.
There is no same rank. As for ROP 17, Lordship, I'm pointing out, Lordship. So what is the
No, you have given something extra, that's what I'm saying.
no, Lordship, that
Not
because
not below the rank of Assistant Director of Industries or its equivalent rank.
yes,
That much is okay.
yes. So how the rank would be determined and equivalency Lordship would be determined. Lordship, kindly. This is the Lordship ROP.
No, that's why. Why have you introduced this ROP?
That ROP because as per advertisement, it was not below the rank of assistant director of industries of
Mr.
commerce.
Datta, you see, this is a post for direct recruitment for the post of Deputy Director of
Deputy
Industries.
Lordship,
Correct.
Lordship.
You're inviting the applications from any other officer from any other department
Any other department.
having equivalent post.
Yes,
Is that the criteria?
yes, Lordship.
Where does the rule say that?
A candidate must rule, Lordship. Again, Lordship, I'll come to the for the post of deputy director of industries and its equivalent post, a candidate must hold responsible and senior position in the government department, government undertaking, at least 8 years of which must have been in the rank not below the assistant director. If I understand that rule, Lordship, the candidate who will-
Okay, in the government department.
government department, Lordship.
Government undertaking for at least 8 years, of which
So
must have.
the rank of assistant director, if we have to evaluate the equivalency of that post in commensurate with that assistant director of so and so, we must go to the 2017 ROP rule, Lordship. What is the rank of assistant director has been given in ROP, Lordship. As per ROP, Lordship, the grade pay, Lordship would find is 13900, Lordship. And the government is requesting to us, Lordship, that not below the rank. So the petitioner would compete for the post of deputy director or functional manager. He should be at least at par with the rank of assistant director of cottage industries, Lordship, having during the pay band 4 and a grade pay of 13900, Lordship, not below than that.
What is the vacancy now? 11.
11, Lordship. And for that, Lordship, the petitioner will have to have minimum experience of 8 years and 5 years of senior position. Now the
Those in the department are also eligible.
yes. There is
Subject
also
to having that experience.
maybe, Lordship, that will be by the department. I am the APSC will be conducting the examination as per their requisition, Lordship. Now we have been given requisition for direct equipment as per, Lordship, Rule 1997, Lordship.
I understand, you see,
Rule 6 prescribed,
for the direct recruitment,
Lordship.
candidate must hold responsible and senior position in government department.
Yes, Lordship.
Now, supposing a person,
Lordship.
assistant director in the industries department, also wants to participate for the direct recruitment, is it possible?
If there is a, if they have the requisite criteria, Lordship.
There's no bar? as per the rules?
As per the rule, they will have to, they have the minimum experience also.
That's what I'm saying. If they have the minimum experience,
Yes,
can they participate?
yes,
They can participate.
participate.
There's no part.
no bar.
Goswami, Mr. Goswami.
Yes.
So Lordship, my,
What is the stage now?
now the
recruitment?
scrutiny has been done, Lordship. Interview is yet to be over, yet to be completed.
What is the scheme of the selection?
The screening test followed by interview, Lordship.
Interview has not happened.
No, Lordship.
Screening is over.
Screening is over, scrutiny is going on.
When will the result be declared?
No, result is not.
The scrutiny is going on.
Scrutiny is going on.
Lordship.
Result not declared.
Not declared. After that,
After that, the viva voce will be there.
Lordship.
I see.
And the prescribed ratio as per our business conduct.
Yes.
Yes, Lordship, the stand of the department, Lordship. Lordship, it is true that requisition made by the department to the APSC. Basically, those are the such type of posts were the selection conducted by the APSC, Lordship. That is the rule of the government. Now, Lordship, what happened, Lordship? The position of the department relating to the advertisement, Lordship. Advertisement aids something not included in the service rules.
Yes.
That is.
Which
that is
one?
the-
Which
yes,
one?
That's it. That is. Lordship, the experience grade pay 13,900. That is not in the rule, Lordship. This is the rule, Lordship.
The rule is here in the book.
Yes, Lordship.
It's in the writ petition.
Yes, Lordship.
You're repeating the same thing again. That's
Yes.
what I questioned him.
That is not in our rule, Lordship.
It's not in your rule.
Yes,
So
Lordship. Page 102, Lordship.
we've seen all this, Mr. Goswami. We have seen all this.
Yes.
So what are you intending to do? What do you intend to do?
Lordship, the stand of the department is that the advertisement adds something in which is not included in the rules. Lordship.
Can you repeat?
As per the requisition of the.
Yes, a requisition we
I have
admitted.
submitted
Yes, we admitted the requisition.
in my instruction. Annexure 1. Annexure, this was the requisition of received by the administrative from the department.
100, yes.
In annexure 3, Lordship, of my instruction, both five in the second page. There has been the first table that was specifically prescribed by the department.
Lordship, Lordship in
So that is your first argument. What is the annexed instruction?
Lordship, 100, Lordship, page 100. Page 100, Lordship. Senior Industry Service, Lordship, grade 2,
Page 100?
100, yes. Assistant Director or Cottage Industries, so and so, so and so, grade is there, the grade pay is there. But it is not 13,900, Lordship.
But you see, this is the rules of 1997, I think, 87, 97. something like that.
It is okay. Yes.
But the rules of 1997, that time we did not have grade pay. It was scale pay.
Yes. Eight to nine, 13,900.
Yes, what else?
Yes, Lordship, that is my stand. Lordship. So far, the department instruct me, Lordship. They stated, I place before this, before your Lordship may pass appropriate order.
See, as I have said, Lordship, I have argued the whole thing, Lordship. The page 100 he has referred. The ROP, Lordship, is very clear, Lordship. In my case, Lordship, all these principal CIT manager industries, Lordship, have to read along with page 100. is all 13,300.
See one thing, you are the departmental officer. Okay. Now, as per the rules, there's two methods. One is through direct recruitment, one is by promotion.
Yes,
Now, you are to compete for your promotion quota,
yes.
correct?
Yes.
There's only one post which has been occupied, the remaining are all vacant.
No,
That steps they have not taken. Now you have come into the direct recruitment quota. Out of the
no, I'm not.
23 posts, that is 25% of 91. There is 11 vacant posts which they are intending to fill up through direct recruitment. So how do you
Through
object to
eligible,
that?
through
How do you-
eligible people, Lord.
Through eligible people?
Yes, they will come above us.
Maybe.
They will be our boss. So someone who is eligible, they will come.
Now, how do you say they're not eligible?
Yes, they are not eligible, Lordship.
How?
That's why,
How?
Lordship. The Lordship, see, at page 102, yesterday also I have
See,
seen.
there's a divide.
Yes,
One is promotion quota, one is direct recruitment.
yes.
You have to stick to your promotion quota. Supposing you have that 8 years or 5 years
I
experience,
can compete, Lordship.
Hmm?
Why not, Lordship? I can also compete.
provided you have provided you qualify.
Yes, I don't qualify because of this. Lordship, 1300, 900 and 1300, 300. My post, all I have given 1300, 300. 13,300. That's my whole problem, Lordship.
You have the number of years of service,
No,
huh?
no,
At least 8 years, out of which 5 years must be in the rank of not
No.
below the assistant director.
No.
So you don't have 5 years of service in assistant director.
I have no.
Then before
It
we
is
move
not
on to
there,
the scale of
It
pay,
is not there. He has a music.
before we move into the scale of pay, you don't have that number of years of experience.
Yes, I have
So-
joined in 2018.
So what is your
2018, I have joined. So I have been promoted in 2024.
as
Now-
assistant director?
Yes.
So you require 5 years.
No.
2024, I become
ADC. This
Huh?
Assistant Director of Industry Lawsuit.
Correct. So the rule says that you must have at least 8 years of service, out of which
It is.
5 years must have been in the rank,
Yes.
not below the rank of assistant director.
Yes.
You were promoted in 2022.
None of these people who is a screen lawsuit have completed in the ADCI lawsuit. That is what I have shown yesterday. Lawsuit, may please see this page 33. They are selected, they are screening all these people. Who are they, lawsuit? Let us see. Page 33, lawsuit, may please come. You will come as our boss now.
Page 33 does not show any
Administrative
details.
report.
It does not give any detail.
No. Lordship, may please come then 81, page 81. The same list is there in page 81. 144 people, Lordship, page 81. All these people have no experience, Lordship, in ADCI, as ADCI.
But how do you show that?
Lordship, let them file affidavit showing that these
No.
people have the.
You are to prima facie satisfied.
No, I know that they are not ADCI.
Huh?
We are ADCI. We know all these petitioner. We know that nobody. All these people.
Who are this list at page 81?
Did that what I have referred to in paragraph page 33, Lordship.
List
is
of
the
candidates for the post of functional manager, project manager, deputy director. These are the,
This is the list of candidates selected by the APC
okay,
for screening test.
okay. So how do you say that they are not qualified?
They are not in the industry service.
They are not in the industry service for last 5 years in the ADCI rank.
No, not required.
Yes, yes,
See,
Lordship.
you come to
Page 102,
you come to the rules.
page 102. Rank, Lordship.
Candidate must hold
Candidate
responsible.
must hold responsible and senior position in the government department undertaking at least for 8 years, of which 5 years must have been in the rank not below the rank of assistant director of industry.
It's only that in industry.
ADI is only there in industry department.
Correct, but it doesn't say that it has to be industries department solely.
Equivalent rank.
It is equivalent rank, Lordship.
Equivalent, that's all, equivalent.
No, they are not. That is what I'm saying, Lordship. No, they are not, Lordship. It is defined at page 87. Lordship, may please come to page 87. Start with 86, Lordship. Rule 3. Rule 3 is the classes and cadres. Lordship, get it? Page 86. It is my service rule, Lordship. Industry service rule. It is the rule 3 is the classes and cadres. Now, Lordship, may please come to page 87. 3. Page 87, 3. The post equivalent to the post of different cadres of the service and include in the respective cadres as on date of the commencement of this rule are given in the schedule 1. Now, Lordship, the schedule 1, Lordship, may please come to page 100. What Mr. Goswami was trying to show to your Lordship, that you has been instructed by the department. That is what the department has instructed, that though we have tell the APSC, they have not looked into it. Now, Lordship, may see this 10, 11, all this. 10, 11, 12, 13. 12, 13. These are the only equivalent ranks. These are the equivalent rank in the schedule 1 of ADI. These are excluded. And it is there in the rule itself, Lordship. You cannot go beyond the rule. Now, by the advertisement, they are excluded. 10 to 13 are excluded. And very surprisingly, Lordship, by the advertisement, they have excluded 10 to 13. All of them are excluded. Because their gate pay is 13,300, not 13,900. All of them are excluded. If people become a senior, I will never become assistant director. If these people will come into the post, Lordship, in my life span, Lordship, I'll never become the additional deputy director, Lordship. Additional director. Right of consideration for promotion will be finished. They have excluded, they cannot exclude, Lordship. Like this, if there is something in the service rule itself. See, we should notice, Lordship, given interim, Lordship, let them come with the affidavit that they have not excluded me, that they have not violated the rule. Correct. 16. Article 16, Lordship, is a fundamental, my fundamental right, Lordship, that right to the promotion and here, Lordship, you know, that. Lordship, I have given everything, Lordship, Lordship will issue notice, let them come with an affidavit, Lordship, not showing some document from here and there and say something, Lordship. When the department has said that we have not sent that, what did the PSC has done?
Department has not told that he has not seen. They have said, I have put the record. As per department, if we.
So you file an affidavit, that department has said that what we have sent, the PSC has not done.
Does not make you case.
No. Department, the government advocate has said that.
No, please
It's not
address,
my mouth.
please address the court. You don't start.
So it is not that what the Mr. Goswami has argued, that is what I have placed. So this page 87 read with page 100.
How do you say you have been excluded because of that pay scale?
Yeah,
What is your pay scale?
13,300.
13,300.
Yes.
For 4 groups, API is different. Standard.
This 10, 11, 12 and 13 at page 100. Page 100, serial number 10, 11, 12 and 13.
They are included perhaps.
No. That's why. Lordship, I've given
See,
this. I have
apart from,
given this ROP yesterday, Lordship. And Lordship can see all these posts mentioned. Even there.
this one, it's here.
Yes.
Yeah, it is there, Lordship. Yes. Third page, Lordship, page 251.
But see, supposing you have the same scale of pay, but what about the numbers of years of service that you don't have?
Not saying I want to compete.
This is the problem.
We do not want to compete. That my right of promotion will be stalled, Lordship, everywhere. If this way, the people from outside will come who are not eligible, Lordship. Otherwise,
Which part is that?
in the page 251, Senior Industry Service Grade 2, Assistant Director of Cottage Industries, Principal CITI, Manager Industrial Estate Bongaigaon, and Senior Quality Control Officer. All these 13,300 except Assistant Director of Cottage Industries. Lordship, in the top, it is 13,900. So I say that this 10, 11, 12, 13 is excluded. So they cannot exclude. Exclusion is not permissible, Lordship.
We get in the advertisement.
So that is the illegality in the advertisement, Lordship. Nothing else. And the industry department does not send that. This is something beyond rule, Lordship. It is not there in the rule at page 102. This part is not there.
Okay, please write. That Mr. Sharma, learned senior counsel, assisted by Mr. Gautam for the petitioners. Stop on 19/8/2026, court passed the following order. Please abstract the entire order. Today, Mr. P.P. Datta, learned standing counsel, APSC, submits that as per the instructions received by him, recruitment of 11 post of Assistant Director of Industries,
Deputy Director.
Deputy Director of,
And Project Manager.
okay, 11 post of Deputy Director / Functional Manager and
Project Manager.
/ Project Manager of Industries and Commerce Department, and person to which the advertisement has been floated by the APSC in terms of the relevant recruitment rules. Stop. Referring to
Annex 3 of my instruction.
the amendment rules of 2014, the learned council submits that in order to determine the rank of in order to determine as to whether the candidate possesses the equivalent rank as that of Assistant Director of Industries, the LPSC has prescribed that the APSC has relied upon the Assam Service Revision of Pay rules, 2017, prescribing the grade pay and pay band.
May I correct one thing? That prescription was from the department of it. Annex 3 of my instruction. Got it from India College Secretary Department. That experience last type. Just communicate to.
Which one? Annex 3?
Annex 3 of my instruction. That the letter dated 5th November 2024 of it.
Okay. Which para?
Lordship, that paragraph 5 was experience, if any. Lordship got it last.
Lordship, I have not got any copy. I do not know what he has given. I have not seen anything, Lordship.
This
This
I
type of-
provide.
You can rely on some document I have not seen. Yesterday you have taken time that
Just
the,
go look
and
us
the
to find
today,
this case. You are
Okay.
first calling the.
you
Just-
give the copy.
No, just a minute, just a minute. He has received the instructions, so we're not disposing of the matter right now. I'm recording his submission, which is as per the instructions received from the Industries, Commerce and Public Enterprise Department through the communication dated 5/11/2024. Stop. He submits that going by the provision of the rules of 2014, there is no part for candidates falling in the candidates having the experience criteria. As per clause 2 of schedule Roman 2 of the service rules. Stop. He submits that currently the process of, what is that? What you are doing right now?
Now scrutiny is going now.
Currently, the APSC is in the process of scrutinizing the
Applications.
applications. And once the same is done, the candidates who are eligible will be called for viva voicing. Next para, Mr. J.K. Goswami, learned
Additional senior
additional senior government advocate,
for respondent 1 to 3.
appearing for the respondent numbers 1 to 3. Submits that as per the instructions received by him, the prescription of payment for and rate
13,900.
pay of rupees 13,900 in the advertisement dated 23/5/2025.
Not as per service rules.
This is not as per the service rules.
Schedule 1, schedule 1.
It's not as per the schedule 1 of the service rules. Okay, one more line that BP Datta. The learned council also submits that the requirement as per the service rules is at least 5 years experience in the grade of assistant director. And admittedly, the petitioners do not have that experience. And therefore, they do not have any local standard to file the instant writ petition. Then you write the submission of Mr. Goswami, okay? I think Mr. Datta will have to share the communication
Sure, right, sir.
with Mr. J.K. Goswami. You have to be clear about your instruction. Mr. Goswami,
Lordship.
you have made that submission, correct? But there's a communication from your secretary fixing that amount, that amount of scale.
No.
So that's why there must be some
Yes,
communication gap.
Lordship, my submission is there. My submission is very clear. My submission is this, as per the service rule, schedule 1, Lordship, the rank of the assistant director gateway of rupees 13,900 is not mentioned in the service rule.
No, your submission is contrary to the communication of the Secretary, Industries, Commerce Department dated 5th of November 2024. That is why you get your instructions.
No,
I'm not saying anything now.
Yes, Lordship.
So that's what I've seen.
Yes. I will take the proper instruction and file an
Next para. Mr. Sharma, learned senior counsel, however, submits that by the impugned advertisement, the post of principal CITI, manager industrial estate, Bongaigaon,
Yes,
senior quality control of officer
yes.
and industries officer have been kept out from the zone of consideration,
Yes.
which is in violation of the rules, which is in violation of Schedule 1 of the rules, recruitment rules.
Yes.
Stop. He also submits that the post equivalent to different cadres of the service has been provided in Schedule 1 of the service rules, which corresponds to Rule 3, bracket 2.
They get 3 lots.
I'm sorry, bracket 3. Rule 3, bracket 3 of the service rules of 1997. So I'm referring to the list of posts which has been accepted to be eligible to apply for the post of deputy director. What is that?
Deputy Director, Functional Manager,
Functional manager
and Project Manager.
and project manager. The Learned Council submits that the same clearly being in violation of the rules. The impugned advertisement as well as the process undertaken thereafter should be interfered with by the school. Next, para considering the above projection, let notice of motion be issued. No, before that, you write above projection, the matter requires further examination. And for which, let notice of motion be issued, returnable by 4 weeks, okay?
No, Lordship,
Today's what?
Lordship, it may be given short date, Lordship.
Short
Because
date.
issue should be settled soon, Lordship.
Okay. Provided you can file an affidavit.
Yes, sir, I will file, Lordship. 2 weeks,
Returnable,
Lordship.
returnable by 2 weeks,
Yes, 2 weeks.
by 9th of September. Mr. Goswami, J.K. Goswami, learned additional senior government, accepts notice on behalf of the
1,
respondent
2,
numbers
and 3, Lordship.
1, 2, and 3.
Yes.
While Mr. P.P. Datta, learned standing counsel, APSC, accepts notice on behalf of respondent number
4 and 5.
4 and 5. Notice is therefore complete. Extra copies be furnished to the learned counsels within 3 days. Okay. Having regard to the above projection, till the next returnable date, the respondents shall maintain status quo as on today.
Lordship.
Otherwise, may observe before notifying the advertisement that leave of the court may be taken.
So the judgment should not be dictated by your counsel.
No, it is
The
my
judgment
PR,
is
my
passed
senior.
and
No,
it
what
should
leave of court?
I have
Very
submitted
unfortunate
before-
matter nowadays.
For notifying the date of interview, leave of the court may kindly be, may be taken. that
Status quo,
observation may be
status
given.
quo, my lord. What is
Otherwise,
it?
status quo will halt entire proceeding. process.
Yes. There are 2
Because
weeks, lordship.
Scrutiny is going on.
When will not fall down?
The scrutiny will be halted.
No, lordship, 2 weeks,
Otherwise,
lordship, you they let them file
continue.
affidavit,
But at the
government is,
time of,
government will
issuing
file
the
an affidavit.
notification for
After the
interview,
dictation,
will come.
lordship. I'm grateful, lordship.
Okay, we'll do one thing then. Let them scrutinize, but you'll not call the interview.
Yes.
Okay. What did I say? The respondent APSC may proceed with the scrutinization of the application, but shall not undertake the process of viva voce without leave of this court.
Before, without, but.
Then lordship can give it 4 weeks, lordship.
No.
They can go ahead, lordship.
Within 2
lordship,
weeks.
let-
No. We'll settle it.
No,
Fact,
lordship.
settle it.
They are.
No, lordship,
Illegal
because my learned friend can say anything, lordship, that
No.
is why I'm saying it may be not 2 weeks.
One more line.
Anything. With due respect to my senior counsel, I'm not saying anything.
One
I'm
more
saying
line.
for a-
One more line. The respondents to file their counter affidavit on or before the next date,
That's it, sure.
so that the entire matter can be taken up for disposal.
Obliged.
And lordship, give an advance copy so that you can file reply, lordship. On the 9th only, they will file an affidavit.
Within 10 days, I will file the affidavit.
So we'll give
Not
a date.
department, APSC, lordship. I do not want an affidavit from the department. I want an affidavit from the APSC. Let them satisfy.
Next week, let's see, I'll file.
Okay.
If my.
So that you can file a reply, lordship.
May I please, your lordship?
Yes.
Your lordship, it's a departmental proceeding, your lordship. Where aggrieved, the petitioner is aggrieved by the order dated 24/8/2023, your lordship, by which the petitioner was dismissed from the service, your lordship. And the unauthorized absent was treated as dice non, your lordship. So we are ready for the mediation, lordship.
The department proceeding case, lordship, how can it settle, lordship? The mediation, lordship.
Why not? Is there any bar?
No, lordship, there is no bar, lordship. It's poor, lordship.
Dismissal from service.
Dismissal from service, that's why, lordship.
You think they'll take you back?
The admission
Department-
lordship.
Problem is the department, nobody will take the responsibility. We'll visit for admission hearing instead.
Your lordship.
Although the counsel for the petition is agreeable for sending the matter for mediation. But Mr. A. Chakraborty, learned state counsel, submits that since the matter pertains to dismissal from service, it may not be perhaps conducive to send the matter for mediation. Considering the same, registry to list the matter for admission after 3 weeks. Not
Obliged.
Lordship, may I pray for a date, your lordship?
3 weeks, I said. On 24th September.
Obliged.
Obliged, lordship.
Yes.
This matter has become infractious.
Huh?
Infractious.
How?
Because my lord, I have challenged the show cause notice, my lord. In the meanwhile, my lord, DP has completed. Departmental proceeding has already been completed. First show cause notice was challenged.
Learned counsel for the petitioner, Mr. What is your name?
I refuse.
Rafiq.
Yes.
Submits that the writ petition has become infructuous. Since the departmental proceeding has been completed.
As Borough. For
Says
August.
Barua, Learned State Council appearing for all the respondents agrees to the submission. Give up the petition stands dismissed as instructed.
My lord, this is a matter of compassionate appointment, my lord. Why we have this writ petition, I am challenging the office memorandum dated 18/9/24, page 36 also.
Hmm.
And relevant portion is page 37, last para.
So should it be sent for mediation or?
No, the compassionate appointment
Okay.
cannot be.
Parties are represented by the respective councils and they submit that since the matter relates to compassionate appointment, it may not be sent for mediation. Yeah, Papa. Matter stands adjourned for 3 weeks to enable the respondents file their counter affidavit.
I am for assignment number 3 as well.
Yes, which has for order. And then state notes appears for respondent number 3. 3.
3.
This again on 24th of September. Give a date.
I appear for 1, 2, and 4.
Your good name?
S. Sharma.
S. Sharma. 1, 2, and
1.
1, 2, and 4. 1, 2, and
8 department.
Diplo.
Public.
My PL, okay, my lord. Please finish the order dated 11/6/26, my lord.
Sorry?
11/6/26, my lord, order dated, please finish, my lord. I'm paying for response number 3 only, my lord. Have been transferred into way back in 2023. In my place, new incumbent has been cut. Petitioner was directed to file to impede the new incumbent, my lord. It's one of 1 and 3.
This is item number
14.
14. You are appearing for
Response number 3 only, my lord.
3.
Yeah.
Yes, what is your submission? You are appearing for the first time?
No, my lord. We have been appearing,
Okay, what is the status of compliance?
my lord, as per of your office for last order, 11/6/26, my lord.
Mhm.
SCPNID will give the status, my lord, as I have been transferred to another department way back in 2023, my lord. In my place, new incumbent has been.
SC, who is that? As Dr.
As Dr.
Who's Mr. S. Doctor? He's not here.
Like,
When were you transferred? When were you transferred?
in 5/8/2023, my lord.
5/8/2023.
Uh-huh.
Respondent number 3, correct? Vikram
Vikram Koili.
Kylie.
Uh-huh. I see Dibrugarh, my lord.
And the order which is not complied with is dated
29/4/22, my lord.
So you were there in
At that time,
22.
I was there. As for the latest instruction, I don't know, my lord. So SCP was
Tell me what you know. Order was passed in on April 22, 2022.
yes, yes,
You got transferred in 2023 only.
yes, sir.
While you were holding the post, what did you do? You were sitting idle.
That's for time being, let me start, my lord. Last time I submitted.
Pensionary benefits be processed and paid to the petitioner within a period of 6 weeks from the date of receipt of a certified copy of the order.
The pension part has not been given yet, my lord. Other part, my GS has been.
None appears for the petitioner when the matter is called for. None appears for the respondents as well, except for Mr.
A for the charge for respondent number 3.
A. Bhattacharjee, learned counsel representing respondent number 3. Stop. He submits that the respondent number 3 has since been transferred to
DC Dibrugarh, my lord.
as Deputy District Commissioner, as
Dibrugarh, District
as
Commissioner.
District Commissioner Dibrugarh
Way back in 5/8/2023.
on 5/8/2023, and therefore he does not have the up-to-date status. Stop. It is seen that the direction of this court is dated 29/4/2022. Directing the respondents to pay the pensionary benefits to the petitioner after due process within 6 weeks from the date of receipt of a certified copy of the order. Of the learned counsel submits that as far as DCRG is concerned, the same has been paid.
GIS has been paid, my lord. GIS has been paid.
CIA,
GIS.
GIS. And what about DCRG? GIS is his money only,
Group
insurance.
insurance. But I don't have that instruction, my
Okay,
lord.
the DCRG, you cancel that. You put GIS instead.
Yes.
As far as GIS is concerned, the petition has been paid. But he does not have instructions regarding the other components such as the pension and the DCRG. Next para, on the last court date. This court had requested Mr. S. Datta, Standing Counsel PNRD, to complete the instructions regarding the status of compliance of this course direction. Up to date, although his name is reflected, he is not present for this court. This matter again. On 2nd of September.
May I please? May I please? The last occasion I was directed to file an affidavit in opposition lordship. It is an additional affidavit lordship. Due to some defect lordship, I could not file it.
You are the Standing Counsel, PNRD?
No, Mr. I'm revenue department.
Oh, you revenue?
Yes. I'm also as doctor.
Huh?
I'm also as doctor. He's also as doctor. I'm also as doctor.
Oh, that's why.
That's the Lord.
May I please, your lordship? I beg to submit for personal appearance of the principal secretary. Affidavit not yet initiated. I am completed just 17 years of service. And the daily wages 25 rupees also pending. In spite of honorable court or not at the daily. I respectfully submit before your lordship to personal appears of the.
Mr. Datta, you are paying for respondent number one.
One, Lordship.
What is the difficulty?
Lordship, one affidavit is sent, but this was due to defect of you could not file it because without signing this affidavit, this was sent to us.
Without signing?
Without signing by the, without identified by the advocate. Not,
No, what is the process?
the affidavit has to be notarized and duly identified by an advocate.
Correct.
But this person was transferred to Lordship Delhi.
Huh?
That this person, that's number one is transferred to Delhi, Lordship.
Number one.
One, Lordship.
You represent number one.
Lordship.
What does the affidavit say?
Affidavit says that we have done our part, Lordship. Now it is pending before the finance department. Lordship.
One is revenue,
Lordship.
principal secretary revenue, huh? Ganendra Dev Tripathi. Where is the judgment of this?
Lordship, judgment page 40, Lordship.
There are 27 page 40. In view of the discussion made in results recorded here, the prayer of the temporary is rejected. However, it is directed that the respondents not putting the respondent 6 shall pay the penal wages in the minimum pay scale, the lowest grade, regular to the date of delivery of this judgment. 4 weeks. Petition is still serving?
Lordship.
In service.
You're still serving.
17 years completed, not yet regularized.
Regularization is rejected.
Rejected.
Now you have to be paid minimum scale of pay
The daily wages.
from the date of delivery of this judgment. That is date 25/7/2024.
Lordship.
So what have you done? Respond number one.
Thereafter, Lordship, we have filed an affidavit, Lordship. Affidavit is,
No, what does the affidavit say? That is what we're interested in.
Lordship, page 59 onwards, Lordship.
What does it say?
That we have done our part, Lordship. We have sent proposal to the finance department, Lordship.
When?
See,
We have already filed the affidavit.
one affidavit filed, that it is additional affidavit could not filed, Lordship. This was there.
So the proposal sent to the finance department is contained in the first affidavit,
No, second.
the second.
Second.
What is the date? When did you send it?
That was filed 24/2026, Lordship.
Huh?
24/2024.
20th April
Lordship, yes,
2026.
2026.
Proposal sent to
Finance department,
by,
revenue department.
what is the detail?
Lordship, this one,
How much is the proposal?
the amount has not been determined, Lordship.
Not determined.
But-
See, the court's judgment is very precise. You have to pay the minimum scale of pay from the date of judgment.
Yes.
Lordship,
So calculation should be from this day, 25/7/2024.
that has not been, but.
How difficult is it to calculate that?
but from-
And what took you 2 years to
First-
calculate?
First time that the concurrence has to be given by the finance department, Lordship. That concurrence has not given, Lordship. Thereafter, we can give the proposal without determining the amount, Lordship.
Concurrence comes first,
Lordship.
then proposal. When did you seek for concurrence?
Last it was 24/2026, Lordship.
Huh?
24/2026.
That is after 2 years. For 2 years, what were you doing?
Before that, Lordship, we have given some opinion of short form from the department and finance judicial department that. Can you see my affidavit, Lordship? First affidavit, Lordship, page 59 onward,
First affidavit,
Lordship,
page 59.
page 59.
Yes, let's see.
Paragraph 5, page 61.
You got to locate page 59 also. What is the date of your affidavit?
Lordship, 6/3/2026.
6-3.
Lots.
Filed by
Respondent number one, Gyanendra Dev Tripathi.
okay, paragraph number.
5 lots.
Yes. Where are you now?
I'm in Delhi, Lordship, on deputation.
Deputation. Before that, you are in the border protection development.
Lordship. I'm so that's part from this.
From revenue, you get to border
Lordship.
protection, then from there to Delhi.
Then, Lordship.
So what does the
That-
latest
that-
affidavit
yeah.
say?
The judicial, we are.
What does it say, latest one?
The latest one that this was pending before the Lordship Finance Department.
Finance department. Since when?
That was
24, 25,
Lordship,
26.
Lordship.
What is that? What is 24, 26?
This one, Lordship.
Any letter?
After this, Lordship. If I'll note, Lordship. First one is judicial department view, Lordship. View given by the judicial department.
Got the judicial department's opinion is dated
26/3/2026.
26/3/2026. Then
Then
finance,
we have enrolled the file to the finance department, 24/2026. Then they have returned the file to us, that is 4/5/2026.
What does it say?
They have sought some legal opinion from the additional advocate general.
It was 4/5. After 4/5, what happened?
We have not received any from the finance department.
Huh?
I think Lordship, finance department stand is required, Lordship, because finance, no, Lordship, he is also part of respondent here. Lordship.
So finance has given their opinion already.
Not even Lordship. Last page, Lordship, just.
Finance department is requested to accord concurrence. Then
Next page, Lordship.
finance department has sent back.
Lordship. 4/5/2026.
In this regard, the legal opinion of legal learned area has been sought on the feasible filing. Finance department is a party here.
Lordship.
Respondent number.
Respondent number, Lordship. Contact. Two, Lordship.
Samir Singha.
Samir Sinha, Lordship.
He is the present finance commissioner.
Lordship, he has noticed steps have never been completed on respondent. He was not holding the post at that relevant time perhaps. So steps were never completed on respondent number 2, Lordship, who is the principal secretary.
Not completed.
Yes, notice was never served upon him, Lordship, because Lordship, when initially the contempt was initiated, Lordship, steps were not required to be taken on respondent number 1 and 2. Only steps were required as per the court's order, Lordship. Steps were only required to be taken on respondent number 3, 4, and 5.
By which order?
Lordship, first order, first. So initially steps were not required to be taken, and later on when the steps were taken, Lordship, by then the respondent number 2. Respondent number 2. Lordship will see the office report, Lordship.
You are respondent number 3.
No.
If I'm referring.
You are 3 or 5?
What?
Huh? Who is 5? Sub registrar. You are occupying the post of sub registrar.
Yes.
Under?
I had forwarded the order to my superior.
Inspector General of Registration. Sub registrar, it comes under the revenue.
Lordship.
Yes.
Okay. So notice was sent only to 3 and 5. Then thereafter,
On the subsequent, one of the subsequent date, Lordship, steps were taken on respondent number 2, but by then respondent number 2 was, the steps were never completed, Lordship, because perhaps by then he had already been transferred, Lordship. So, Lordship, I'll pray that some time may be granted, because since the current incumbents are not here, some time may be granted so that in the meantime, the petitioners can take the steps on the current petitioner, current office holders, Lordship.
See, there's one order here,
Lordship.
11/8/25.
Lordship.
Since notice was not issued to the respondent numbers 1 and 2, none appears for the respondent number 2.
Lordship.
However, Mr. S. Datta submits that notice has been received from the registry,
Yes.
and therefore he appears to represent respondent number 1.
One.
You.
Not two, Lordship.
2 is the finance.
Yes, two is final, Lordship. So I'll pray, Lordship, I'll get the necessary instructions.
So whether instead, although notice was not issued, you received the notice.
Lordship, we have received notice from the
How did
registry,
you-
Lordship.
How did you receive?
From the Lordship. This is the notice.
Okay. Who is the current finance secretary?
Commissioner and Secretary, Lordship, I can give the Lordship because he has not been served, and if we are required to file any affidavit or furnish any details, Lordship, his implement will be required. In the meantime, Lordship, I can, or else I can, if Lordship directs, I can produce a update regarding the case. Because the present commissioner, they have never been put to notice regarding the contempt law. Sometime I am only.
Okay. Third, Mr.
M. Talukdar.
M. Talukdar,
For the petition.
learned counsel for the petitioner, who submits that the order of this court dated what is the date? 25/7/2024. Passed in WPC number 7880 of 2022. Has not been complied with. So a perusal of the order annexed as an extra F to the contempt petition, more particularly at paragraph number 27, shows that the respondent numbers 3, 4, and 6 have been directed to pay the petitioner wages at the minimum of pay scale extended to a regular extra writer from the date of delivery of the judgment. So the respondent numbers 3, 4, and 6 are the Inspector General of Registration, Assam, the district registration, the district registrar, Dhemaji, and the sub-registrar, Jonai, respectively. Now, on 19/3/2025, court had issued notice only to respondent numbers 3 and 5, 3 to 5. Who were the respondent numbers 3, 4, and 6 in the writ petition. What is the stand of the registrar? Yes. What?
6/25.
What is your stand?
Para 4 and para 5, I immediately forwarded the order. My superior authority, and thereafter I have been released from the post. I resigned from the post and I am released from the. When the order came to me, I immediately forwarded my inspector general on necessary action. And subsequently, I resigned from the post.
Okay.
Para 4 and para 5. And it starts at page 47.
What is your good name, please?
Keta.
K. K. Talukdar. Correspondent number?
5.
Mr. K. Talukdar, Lanet Council, correspondent number 5, submits that. The respondent number 5 has resigned. Has resigned.
Yes.
Why?
That's not he has tendered his resignation and thereafter has been relieved because he subsequently got qualified for the ECS under the EPC
Has resigned from the post of
of sub-registrar.
Sub-Registrar Jonai
Jonai on 17/2/2020.
on 17/2/2025.
And he was released from 1/3/2020.
Since he got a better employment elsewhere. Stop. He, however, submits that during his tenure, he had forwarded the proposal before whom?
Inspector General.
Before the Inspector General.
On 7/8/2024.
On 7/8/2024. Stop. Although notice was not issued to respondent number 1, but the respondent number 1 has received registry, has received the notice, and Mr. S. Datta that represents the respondent number 1. The learned counsel submits that an affidavit was filed by respondent number 1 on your last affidavit.
First affidavit, Lordship, 6/3/2026.
No, before that you did not file.
No, 6/3/2026, first affidavit. Lordship.
First, okay. Was filed on 6/3/2026. And he submits that another affidavit is being prepared, which however would not be filed on account of lack of identification of the deponent by an advocate or advocate's clerk. To stop, the said affidavit was sent from Delhi,
Lordship.
since the respondent number 1 is posted now in Delhi. Stop. He, however, submits that the matter now rests with the finance department, since
24/2026.
24/2026. After the opinion of the judicial department was obtained. According to his information, the finance department has sought the legal opinion from the learned additional AG on the matter with regard to the feasibility of filing appeal or review. Considering the submission, the respondent number 1 shall file the affidavit in corrected form. When will you file?
In 10 days, I can file.
Within 10 days from today. To stop, Mr. H. Alia, Learned Standing Counsel, Finance Department, is requested to get the update instructions with regards to the compliance of the court's direction. The petitioner shall also consider pleading the present incumbent holding the post of Commissioner and Secretary, Government of Assam Finance Department. This is the matter again. After 10 days, okay?
So I'll pray for a week, September 1st week. First week.
This is the matter again on 7th of September.
Lovely.
Yeah, come back in 5 minutes.
May I please, Your Lord?
Yes.
Also, in this case, the present applicants in the interlocutory application, Lordship, are the petitioner number 1 and 2 in the connected writ petition, Lordship. They are seeking relief of pensionary as well as death benefit of their deceased father, who was working as a constable in the excise department.
Okay, who's for the respondent? Private
I
respondent,
appear for the excise department.
excise. You have
What?
released 5 lakhs plus.
We have received, because we are seeking instructions on it. I have just received an instruction right now regarding the amount. That is,
Why have you
we have
released?
received a specific amount.
If Your Lordship kindly peruse the last order, page number 16, Lordship,
The-
23-7.
Just a minute, the private respondent is not represented in the writ petition.
No, Lordship. There is a order, Lozima order, Lordship, where she refused to accept the
Oh, she
notice.
refused.
Yes, she refused to accept the notice. It is on record, Lordship.
Yes, you are referring to which order?
Right now I am referring
No,
to
in the IA.
page number 16,
16.
23-7, 2026. The last order of this honorable court, in fact. On that day also, my learned friends, counsel appearing on behalf of the department, seeking time for necessary instruction regarding the payment. In fact, prior to this order, Lordship, they released 5 lakh something rupees to the respondent number 5.
So why have you filed this IA?
Recently on 18th, I have submitted a representation before the excise department, page number 21 of my petition, Lordship, annexure 5 of IA, page number 21. I approached the superintendent of respondent number 4 office. Therefore, I came to know that already 2 parts, GIS and leave encashment released to the opposite party. Then I submitted this representation to stop the remaining payment until disposal of the writ petition.
What is released now? GIS
and leave encashment.
and what remains?
And the remaining area as well as the pensionary benefits are remaining, they have to pay. And Lordship, the amount was altogether 5,27,480.
So why have you filed this IA?
Lordship, they inform us that there is no order from this honorable court for stay of or any such order. So they are going to pay the remaining amount into the account of the respondent number 5 within 2 or 3 days. Because Lordship may kindly see the order passed by this honorable court in page number. For a moment, page number 17, middle portion of the order. Accordingly, page number 17. Accordingly, Lordship may kindly see. Page number 17. Accordingly, list the matter on 24/8/2026 to enable the learned standing council of excise department to place updated instruction as regard the petitioner's claim for arrear salary and pensionary benefit. And next paragraph, Lordship, it is however made clear that the issue involved in the present writ petition pertains to the non-payment of the arrear salary and pensionary benefits to the petitioner. Having regards to the nature and urgency of the matter, respondent authority shall positively take all necessary steps to resolve the issue by the next date of listing and place the outcome before the court. Lordship, what happened when Honorable Court observed these things? So they are now in a very haste, Lordship, they want to pay the remaining amount to the respondent number 5. Then it will cause serious prejudice because what happened, Lordship? We are the son and daughter and son of the deceased person. She is the second wife. We are not disputing.
Yes, I know, Mr. Counsel, I've read the file.
Yes.
So when I asked you why you have filed this IA, you should have immediately said that you want direction for stay of payment.
I
That's
filed
all.
this IA. Yes.
That's all.
Yes.
What is your instruction?
Because we have been, there's in our affidavit in opposition, Milords, in our affidavit in opposition, page 50 of our affidavit in opposition, they have made they have reached an agreement that the whole pensionary benefits will be shared with the
Correct.
parties.
You have also said that pension can be given only to one.
Only one,
But
it's mentioned in the rules.
there can be an agreement between the two.
No.
Pension will be given to one, they will share.
Milords, so
Now
in
problem is
way
that
we-
respondent number 5 is not accepting the notice and is not sharing also.
Yes.
So we'll stay the process. Heard, Mr.
PP Borthakur.
P. Borthakur. PP Borthakur, learned counsel for the applicant, who submits that the applicants are the petitioners as well in the main writ petition. And by filing this application, they seek for a direction to the respondent excise department not to release the arrear and pensionary benefits to the respondent number 5. Stop. He submits that an amount of rupees 5 lakhs. Okay, I'll give you numbers. 527,480, correct?
Lordship.
Has already been released to the respondent number 5, which is towards the GIS and leave encashment of late
Moon Talukdar
Moon Talukdar,
was a constable of excise department.
who was the constable of the excise department. Stop. The learned counsel submits that the applicants are the son and daughter of from the first wife of late Moon Talukdar, and the respondent number 5 is the second wife. Stop. Although there was an agreement mutually. No, right like this. Although there was a mutual agreement between the parties to share the dues and benefits of the late employee, but instead of sharing the amount, the entire amount towards GIS and leave encashment has been given to the respondent number 5. And therefore, respondent authorities may be directed not to release the remaining balance, which is left. In respect of the arrear and pension benefits. Next para, in view of above, issue notice returnable by 9th of September. Mr. S. Sharma, Learned Standing Counsel, Excise Department, accept notice on behalf of respondent numbers 1 to 4.
I am for respondent number 2.
Okay. Deputy Commissioner Excise. Deputy Commissioner Excise 1 to 4. Extra copies be furnished to him within 2 days. Petitioner to take steps for service of notice upon the respondent number 5 by speed post within 3 days. Having regard to the projection made, the respondent authorities are directed not to release the remaining arrear and pensionary benefits of late
Moon Talukdar
to the respondent number 5 without leave of this court. List again on sense. What is the returnable date? 9th.
Lordship,
This one.
if possible, Lordship, he may communicate to the authority today itself, because I have to obtain the certified copy and to produce for the authority. In the meantime, they may be release it to the respondent number 5, and then it will possible. Then he may communicate them to our phone also, that there is an order from this owner.
A copy of this order be furnished to the learned counsel for the applicant as well as the standing counsel excise department during the course of the day. For onward communication to the respondent authorities concerned. You'll get a copy. Yes.
Obliged.
Twenty-five. Okay.
May it please your lordship.
Yes.
I think my learned friend has completed his part.
With reservation to file to submit a reply.
Of course, of course.
Yes.
My lord, if your lordship would kindly come to paragraph 10 of the writ petition.
Yes.
The petition is One second.
Page 7.
Yes. Sorry, Milord, paragraph 11 at page 7.
Yes.
That the petitioner would like to mention here that APR for the last 5 years are checked by DPC at the time of promotion. And thus even in 21, his earlier APR would have been minimum rating of good, and as such, his promotion to higher post was considered. That the petitioner states that the FCI headquarters circular dated 9/7/21, which deals with periodic review of the corporation employees under regulation 22 mentions point number 10. No corporation employee should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years or where has been promoted to a higher post during that 5 year, his service in a higher post has been found satisfactory. In this context, petitioner would like to reiterate that his APR for the period July 21 to December 21 has outstanding rating, which is again a testament to the fact that the work performed by him in the promoted capacity of DGM has at least been found satisfactory by his reporting, reviewing, and accepting officer. Thus, decision taken by respondent number 2 is in violation of the above given guidelines for review under regulation 22. So, Milord, in this paragraph, what the petitioner would like to emphasize is that since he was promoted during the last 5 years, therefore the decision taken to compulsorily retire him is not correct. Milord, his promotion was not based on merit. His promotion was based on seniority. It was a promotion based on seniority. Now, Milord will kindly take paragraph 12A. Sorry, para 13 at page 8.
Yes.
That the petitioner states that the FCI headquarters circular dated 9/7/21 stipulates that the broad criteria to be followed by review committee while making recommendation for premature retirement. The petitioner in utter shock and disbelief and is not able to comprehend under which clause guideline the review committee had recommended his name, while the petitioner's performance has been judged outstanding. At the same time, no question has been raised on his integrity till the date to any higher officer. In other words, my lord, what the petitioner is basically trying to project is that since his performance was otherwise found satisfactory, since he earned a promotion during the relevant period, therefore the review committee's decision to recommend premature retirement is wrong. Before I deal with the argument, my lord, let me place 2-3 paragraphs from my affidavit where we have brought out the actual facts, which are not there in the writ petition. Now, please come to page 58, my lord, para 15. Para 15. Yes. That the statements made in paragraph 10 of the writ petition, save and except the statements borne out by the record, are not true and correct, and the same are hereby denied. In this connection, I say that clause 10(5) of the circular dated 9/7/21 states that the entire service record of a corporation employee should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to consideration of APAR dossier. The personal file of the corporation employee may contain valuable material. Similarly, his work and performance could also be assessed by looking into files dealt with by him or in any papers or reports prepared and submitted by him. It would be useful if the concerned internal committee puts together all the data available about the corporation employee and prepares a comprehensive brief for consideration by the review committee. even uncommunicated remarks in the APAs may be taken into consideration. Therefore, I say that while passing the order dated 8/5/23 by the appropriate authority, that is Managing Director of the FCI, the entire service record of the petitioner was taken into consideration and it was not confined to APAR dossier only. In other words, my lord, what we contend is that entire service record, including the APR, were taken note of. Therefore, the assertion in the repetition that merely because they're merely based on APR dossier, my lord, the impugned decision was taken is not correct. Then please come to para 16. That the statements made in paragraph 11 of the repetition 7, except the statement borne out by the record, are not true and correct, and the same are hereby denied. In this connection, I say that the petitioner was promoted to the post of Deputy General Manager in accordance with the procedure of promotion. However, it is stated that petitioner was graded fair during 2013 while working with other seven different controlling officers. He was barely graded at the minimum benchmark grading that is good to keep his promotional avenues open. So, these are his actual profile. That the petitioner states a statement made in paragraph 12 of the writ petition 7, except the statement borne out by the recorder not true and correct, and the same are hereby denied. In this regard, I say that clause 10.4 of the FCI circular dated so-and-so states no corporation employee should be ordinarily retired on the ground of ineffectiveness. If his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the higher post has been found satisfactory. There is no such stipulation, however, where corporation employees to be retired on grounds for doubtful integrity. In case of those corporation employees who have been promoted during the last 5 years, the previous entries in APARs may be taken into account if he was promoted on the basis of seniority cum fitness and not on the basis of merit. So, my lord, if the promotion criteria is seniority cum fitness, then, my lord, this criteria would be applicable. And in fact, the promotion which the petitioner earned during the last relevant period, it was based on seniority cum fitness. That means essentially, my lord, it was not a merit-based criteria. In other words, what we call seniority cum merit. The position being, my lord, unless someone is unfit, then he will naturally be promoted, he will still march over his junior. So, my lord, in a situation where criteria is seniority cum merit, there is no occasion to assess the merit. Only thing that is required is whether he is fit or unfit. If he is fit, then he will be promoted. So their merit does not come into play, my lord. That the word ordinarily used in the above clause clearly suggests that the competent authority is not completely precluded from passing order of compulsory retirement under regulation 22(2) of the staff regulation if the employer is promoted during the last 5 years. However, the second part of the clause further clarifies that if the employee was promoted during the last 5 years on the basis of seniority cum fitness and not on the basis of merit, the previous entries in APRs can be taken into consideration. The case of the petitioner is clearly covered under the second part of clause 10.4 of the circular dated 9/7/21, as promotion of the petitioner was made on the basis of seniority cum fitness and not on the basis of merit as per standard policy followed in the corporation. So, my lord, there is no gainsaying that his promotion was not, my lord, on merit, it was based on seniority. Therefore, my lord, there is no, bar on the part of the authority to review the case of the petitioner. Now, please come to para 18, my lord. This is the most important para, my lord. This will reflect on the entire service career of the petitioner. Page 61. That the statements made in paragraph 12A of the writ petitions are not wholly correct and as such are denied by me. In this connection, I say that the Vigilance Administration profile of petitioner reflects the following position. the petitioner was charge sheeted under Regulation 58 of the staff regulation, white memo, so issued by the managing director, and he was imposed penalty of reduction in time scale of pay by 2 stages for 3 years. Well, there is no whisper about all these facts in the writ petition. That he was imposed so many penalties, there is no whisper in the writ petition. Was it not expected of a petitioner who is seeking equitable relief to come up with all facts? These are all suppression. And it's a major penalty, my lord. A reduction in time scale of pay by 2 stages for a period of 3 years and shall not earn increment during the period of such reduction. The penalty shall have effect of postponing future increment of pay while order dated so and so. 2. The petitioner was charge sheeted under Regulation 60 of the staff regulation, white memo bearing so and so issued by the managing director of the SBI, and he was imposed penalty of withholding of 1 increment for a period of 1 year without cumulative effect. My lord, punishment 1 is major, punishment 2 is minor. Then 3. Petitioner was charge sheeted under Regulation 58 of the staff regulation white memo issued by the so and so, and he was imposed the penalty of stoppage of 1 increment for a period of 1 year without cumulative effect. It's a major punishment, Miller. 4. APR grading of the petitioner also reflects that he was graded as fair during the year 2013, and while working with other 7 different controlling officers, he was barely graded at the minimum benchmark grading to keep his promotional avenues opaque. His integrity during the year 2012 was not recorded by his controlling officer, also not clearly certified as beyond doubt by his 7 controlling officers. Rather, it was stated that nothing adverse came to notice, which cast serious doubt on his fitness to be considered for continuance in service. 7 of his superiors, my lord, had just gave a casual thing. So this is the servile profile of a person who has been, my lord, compulsorily retired. Now, my lord, having regard to the facts of the case, now, what is the scope of FR 56J? That is the only point to be decided by your lordships. Now, I'll rely upon 2 decisions of the Supreme Court, my lord. The well-known first judgment is of Vaikuntha Nath. My lord, this Vaikuntha Nath Das's case is considered to be a Bible on this subject, my lord. If your lordship should kindly come to paragraph 34. At page 315.
Yes.
The following principles emerge from the above discussion. An order of compulsory retirement is not a punishment. It implies no stigma, nor any suggestion or misbehavior. The order has to be passed by the government on forming the opinion that it is in the public interest to retire a government servant compulsorily. The order is passed on the subjective satisfaction of the government. Kindly mark this word. So there is an element of subjectivity. Therefore, what would be the scope of judicial review, which is the next, my lord, relevant question which comes into play. The principle of natural justice has no place in the context of an order of compulsory retirement. This does not mean that judicial scrutiny is excluded altogether. While the High Court or this court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed mala fide, that it is based on no evidence, that it is arbitrary. So, my lord, in my humble understanding, my lord, what follows from this passage of the Supreme Court judgment is, on 3 grounds, my lord, judicial review can be extended First, if the exercise of power is not actuated by malefides, which is not even the petitioner's case. Is not the pleaded case. And second, my lord, is very important that it is based on no evidence, meaning that it is based, if there is some evidence, end of the matter. It's something like, my lord, in a disciplinary proceeding, when your lordship finds that it's a case of no evidence, then court will not interfere. But if your lordship finds there is some evidence, because preponderance of probability is the standard of proof, so there my lord will not interfere. So my lord, end of the day, the well-recognized judicial grounds are the grounds also for interfering in a, my lord, compulsory retirement, and that it is arbitrary. Now, arbitrary is an expression, my lord. End of the day, when we say it is arbitrary, then supposing, my lord, Article 14 is violated, supposing, my lord, a manner prescribed is not followed. Sometimes, my lord, there is no jurisdiction yet power is exercised. So it falls in none of these categories. So it is neither arbitrary. Then, in the sense that no reasonable person would form the requisite opinion on the given material, in short, if it is found to be a perverse order. Now, having gone through, lordships, after noticing the facts in paragraph 18 of our affidavit in opposition, can it be said that the Witnessbury principle will apply? That no prudent person could have taken a view that this man is required to be compulsorily retired. No. There are, my lord, materials which enables the authority to make an order of compulsory retirement. Then, my lord, 4. The government or the review committee, as the case may be, shall have to consider the entire record of service before taking a decision in the matter, of course attaching more importance to the record and performance during the later years. The records to be so considered would naturally include entries in the confidential record, character roll, both favorable and adverse. If government servant is promoted to a higher post, notwithstanding adverse remark, such remark lose their sting, more so if the promotion is based on upon merit and not upon seniority. Even if he is promoted, my lord, then also, if the government servant is from a higher post, not with adverse remark, such remark loses their sting, more so if the promotion is based on so and so. An order of compulsory retirement is not liable to be quashed by a court merely on the showing that while passing it, uncommunicated adverse remarks were also taken into consideration. Circumstances by itself cannot be a basis for inference. Inference is permissible only on the grounds in 3 above. These aspects have been discussed in so. So, my lord, Vaikuntha Das's judgment is the judgment, in my humble submission, to my lord, find out whether the exercise of the power is proper, and if not, what is this extent and scope of judicial review. Now, my lord, having noticed the facts in paragraph 15 to 18 of the affidavit in opposition, can it be said, my lord, that it's a case where relevant considerations were not taken off, or consideration germane were not taken off, or it is an arbitrary exercise of power? In my humble submission, my lord, end of the day, my lord, there is an element of subjectivity in the entire decision-making process. And that your lordship will have to recognize at the hands of the employer. Sometimes, my lord, this subjective satisfaction is not possible to be measured in terms of, my lord, unit or something. There some leeway has to be considered to the authority. Of course, my lord, your lordships will have to also record a finding that there is no arbitrary exercise of power or malafide is involved. The moment, my lord, the element of malafide creeps in, then, my lord, this otherwise the clear picture, my lord, fades away. Therefore, my humble submission is, my lord, this element of subjectivity which is there, that needs to be recognized in such matters. Now, my lord, there's one more judgment Ramachandra Raju's case, my lord. 1994 supplementary 3 SCC 424. I'll rely on two paragraphs, paragraphs 8 and 9. Now, my lord will kindly come to page 430, my lord.
Yes.
Now, I'll read from Placitum B, my lord, after a third sentence. This court, considering the scope of Fundamental Rule 56J on the anvil of the administrative law, held that order of compulsory retirement has to be passed on forming the opinion that it is in public interest to retire a government servant compulsorily. Though the order is passed on the subjective satisfaction of the government or review committee shall have to consider entire record of service before taking a decision in the matter. Of course, attaching more importance to the record of and performance during the later years, the records so considered would naturally include entries in the confidential record, character role, both favorable and adverse. The order of compulsory retirement is not liable to be passed on mere showing that while passing it, uncommunicated adverse entries were taken into consideration. Further, this does not mean that judicial scrutiny is excluded altogether. Though the court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is made mala fide or passed on no evidence, or that it is arbitrary in the sense that no reasonable person could form the requisite opinion on the given material. In short, if it is found to be perverse order, the remedy under 226 is an important safeguard, since the remedy is an effective check against arbitrary and mala fide or perverse action. It is the settled law that though the order of compulsory retirement is not a punishment, and the government employee is entitled to draw all retirement benefits, including pension, the government must exercise its power only in public interest to effectuate the efficiency of the service. The deadwood needs to be removed. Now, this is the line, Miller. To augment efficiency, integrity in public service needs to be maintained. The exercise of power of compulsory retirement must not be honed on public servant, but must act as a check and reasonable measure to ensure efficiency of service and free from corruption and incompetence. The officer would live by a reputation built around him. In an appropriate case, there may not be sufficient evidence to take punitive disciplinary action or removal from service. But his conduct and reputation is such that his continuance in service would be a menace in public service and injurious to public interest. The entire service record or character roll or confidential record maintained would be furnished the backdrop material for consideration by the government or the review committee or the appropriate authority. On consideration of the totality of facts and circumstances alone, the government should form an opinion that government officer needs to be compulsorily retired from service. Now, my lord, what follows my humble submission would be, my lord, there may be a case, my lord, where the employer is seized of materials, but materials are not of such a magnitude or character that even if a disciplinary proceeding for dismissal is instituted, my lord, then it may not succeed. At the same time, the employer is conscious of the fact that this man is incompetent, he is a deadwood, he needs to be removed. End of the day, my lord, it's a concept which has been evolved in the service students basically to weed out deadwoods. If you go by the early judgments of the Supreme Court, my lord, Supreme Court used the expression weeding out of deadwoods. There are people, my lord, may not be bad, may not be corrupt, may not be, but is thoroughly incompetent. But here is a case, my lord, is a mixture of both. He has had 3 punishments. Fair recording, not even good. Promoted based on seniority. Now, this much of discretion, my lord, provided attending facts and circumstances are taken note of has to be considered to an employer. End of the day, my lord, this is an action which is in public interest. Because unless an employee performs effectively and efficiently, my lord, he is a burden to the organization. So that much of leeway. Therefore, my lord, end of the day, in my humble submission, what is more important in such matters is, my lord, number one, lordships, end of the day, what it is. Lordship is not examining the decision to retire him compulsorily. What your lordship is examining is the manner in which he is sought to be, my lord, compulsorily retired. In other words, whether the rule prescribed procedure has been followed or not. Now, my lord, the relevant regulations, everything has been followed. Therefore, in my humble submission, my lord, it's an open and shut case where, my lord, the authority has scrupulously followed the prescription in the guidelines and the rules to be followed in the matter and has rightly passed the order, and it does not call for any interference, my lord. More so, the view taken is not such an unreasonable view that it would be hit by the Witnessbury unreasonableness.
One thing, Mr. Chaudhary,
Lord.
you were referring to that promotion
Yes,
based on
seniority.
seniority.
Yes.
Uh, Seniority come fitness,
Yes.
not seniority come merit. Now, where do we have that in the under the FCA guidelines? Is there
Yes.
anything as such?
Yes. I have quoted that in my paragraph, my lord. If your lordship will kindly come to paragraph 18, my lord. Sorry.
Page 60, you have quoted.
Yes. That's okay.
Seniority come fitness and not on the basis of the standard.
Or lordship will kindly come to page 46, my lord, of the writ petition. Am I affiliate? Page 46. Yes. Romans 4, my lord. At second para at page 46.
Yes.
No corporation employee should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found satisfactory. There is no such stipulation. However, where the corporation employee is to be retired on the ground of doubtful income, those corporation employees who have been promoted during the last 5 years, the previous entries in the APRs may be taken into account if he was promoted on the basis of seniority cum fitness and not on the basis of merit.
Now, what is the material available to show that he was promoted on seniority cum fitness?
Millard.
What is the material
Ah,
to show that petitioner was promoted not on merit but on seniority only?
that averments we have made, Millard. That averment we have made in paragraph 18, I suppose. Also.
There is no dispute
Like
on that.
in some organization, you have this
Yes.
time scale promotion.
Yes. Yes.
Because of
Timescale.
your seniority,
That's all.
whether you have that thing or not, you move on like that
Page 60, Millard.
to a certain stage.
Page 60, Millard. The first subpara, last 5 lines. The case of the writ petitioner is clearly covered under the second part of clause 10.4 of circular dated 9/7/21, as promotion of the petitioner was made on the basis of seniority cum fitness and not on the basis of merit as per the standard policy followed in the corporation. If your lordship wants, we can produce the record also if necessary. That was
No, this
promoted.
again relates back to that 10.4 only.
Yes.
You have read that 10.4 already?
Yes. No, Millard, because 10.4 is the provision, related provision, Millard. That's why I have referred to that. And if your lordship wants to have have an access to the record to show that he was promoted on seniority cum fitness, that we can do. And that is not disputing either, my lord.
But we have not disputed that fact. Seniority cum fitness.
Seniority cum fitness. There is also seniority cum merit.
Same thing. Seniority cum merit, seniority cum. Because in service jurisprudence, basically there are three categories broadly. my lord. One is seniority cum merit, other is merit cum seniority, and third, there are very few cases, my lord. Seniority, seniority and merit with due regard to suitability and merit with due regard to seniority.
Here is seniority cum fitness.
The pure and simple seniority. As long as a person is not unfit, by virtue of his seniority, he will still emerge over his junior.
Somehow,
In case of senior merit comes seniority, my lord, even if junior has a higher merit, then he will supersede his senior in the feather category.
no, is there any difference at all in the context of the present FCI regulations
And
that there are two methods of promotion. One is by merit, the other is by fitness. only.
yes.
So petitioner belongs to which?
If he was promoted under the category of seniority cum fitness.
Fitness. So where do we get that in the entire regulation?
Well, again, but that is a question pertaining to condition of service. So that will be in the recruitment rules, Miller.
Because what you were trying to project was that here got his promotion by dint of his seniority.
Yes.
Not on merit, because the desirability to keep in the service has been shown by the manner in which he has been imposed various penalties, two major penalties, one minor penalty.
Actually, my lord, criteria of promotion and all, these are all contained in the recruitment rules, my lord. Framed under proviso to Article 309. Normally, these are concepts associated with, my lord, condition of service. So this will be, naturally it will be there. We can get it, my lord. We can place it on Monday, we can give it, my lord.
Otherwise, you see,
No,
generally, if one is promoted, one gets the impression that, okay, he's doing well in his career. He got promotion. Nobody says that he's not doing well, but still is promoted. That'll be.
We have given enough hints in the affidavit also to say the fact that, my lord, he was given some good grading only to keep his promotional avenues open. Otherwise, a fair or unfit becomes, he won't get a promotion also. But end of the day, my lord, the FCA and all, my lord, these are all corporations. A performance-based thing, my lord. You can't fit deadwoods. So they want to weed out deadwoods. That's basically the idea. And that is a course of action which is permissible in law. Therefore, my humble, no, I can place that on Monday, my lord, that recruitment rule which makes. And my lord,
if there's anything like that.
My landed friend is he got a terminal benefit of more than 1 crore 10 lakhs. 1 crore 10 lakhs 30,326.
No, you would have got that anyway, isn't it? This is not a penalty.
Anyway, my lord, I'm not trying to say that. No, it is not a penalty.
No, it's not a penalty. So they say that you weed out that with deadwood.
That's why, my lord, I made that submission, my lord, for lordship's kind consideration. That element of subjectivity which exists needs to be recognized at the hands of the employer. My lord, on Monday, I can
Only that point. Only that point regarding whether there is a provision for promotion by dint of merit and one is just by time scale promotion like fitness and seniority.
We'll give that on Monday.
All right.
Because you can keep it at 3 o'clock. I'll just 10 minutes time, I'll do that. Monday, huh? So that is my humble submission for us.
Okay.
Deeply.
Mr. Dubey, you have 5 minutes.
In fact, it would be better if I can give my reply once that is produced before your lordship. Because your lordship would see in my petition, para 9.
No, that is only just to clarify one point. That's all we see. What do you want to reply now?
Well, you would see para 9 of my averment in petition, lordship. That has not been denied by them.
Para 9 says?
The petitioner said it is required 5 years of experience as assistant general manager for the post of deputy general manager. The petitioner also stated that the minimum benchmark for annual performance assistant report APAR grading for the post of DGM is good, and the previous 5 APARs along with vigilance and administrative clearance. So though per se it can be seen as a seniority come fitness, my lord, element of assessment of the fitness is there. And my lord will kindly see what regulation 4 says of the circular, my lord, that lordship has read. Page
Correct. See, the benchmark minimum is there, isn't it?
Yes.
In some posts, it's like very good. Unless you don't have the benchmark of very good, you don't get considered. But here, the benchmark is good. And according to you, you have got that group grading.
Yes.
That fair grading was given to you also.
2013.
13, okay, previously.
When
This promotion happened in 2021.
20. Lord, there is no dispute as regards the proposition that's been submitted before your lordship's lord. Rather, we are also relying on the same. Lord, the test is whether a reasonable man will take that decision or whether I am a deadwood. If your lordships kindly come to page 95.
Yes.
Let's say I'm working in 2021, having a APAR grading of outstanding up to 2019. Can I be considered as a deadwood for the person who has accepted my gradings, including the MD, my lord? He should rather be a deadwood who is accepting the recommendation of outstanding, my lord. Was this accepted without application of mine on the part of the authorities? And Lord, when the law says that you have to have a entire career, can only a focus of one fair in 2013 would amount to totality, seeing the service record in totality? That proposition has been let down, that even beyond that, adverse remarks can also be looked into. But neither in the affidavit or the record, they could show that there are some adverse remarks against me. Now, lordship sees page 46 for a moment, my lord.
Page 40.
46 of the writ petition, not that Roman 4. What does it forbid, my lord?
Yes.
No corporation employee should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found satisfactory. Lord, if I am promoted and they are giving me outstanding, my lord, that comes into play. Again, Lord, there is no such stipulation, however, where the corporation employee is to be retired on the grounds of doubtful integrity. Lord, still if I have Lord, good function, Lord, and satisfactory performance. But if my integrity is doubtful, my lord, they can still resort to this provision. In case, Lord, this is important. In case of those corporation employees who have been promoted during the last 5 years, the previous entries in the APAR may be taken into account if he was promoted on the basis of seniority cum fitness and not on the basis of merit. But this has got a very significant meaning, Lord. It says, if I am promoted on merit, they are not entitled to look in my previous APARs. End of the matter.
That's why I asked this question.
Yes, my lord. Now your lordships comes.
You only accepted that you were promoted on fitness.
Yes, I'm what it says. You may look into my previous years. Definitely you look in. I'm not denying that they can't look into the APARs. But would it be reasonable to look into only one fair entry in 2013 and then take a call that I am a deadwood, my lord? And my lord, 94 judgment that has been read by learned senior friend, my lord, it says that the later part should have a more weightage. No, they have obliterated the later performance, my lord.
Yes.
So, my lord, when they themselves say the entire record, they are confining them to one entry. And then the punishments meted out to me, still there is no adverse remark as regard my integrity, your lordship has seen in page 95. These are all stale things, on the basis of which I am punished in 2023. And therefore, there is a perversity, and your lordship's hands are not bound, that your lordship cannot interfere. It's correct, your lordship in 226 is examining the decision-making process, not the decision itself. But your lordship sees how it's been done. Can a reasonable man can say that I am having last 5 outstanding remarks being promoted in DGM. I am a deadwood, I am not functioning well.
Okay.
One aspect, in your lordship's last order, your lordship was recorded in January 2025. I am to retire. It's actually 4/1/2026. In January 2026, it should be.
Is it so?
Yes, yes. If your lordship sees page 20, 126. Page 20, my date of birth is given. It's 5/1/1966.
Ah, correct. This should be 26.
26.
There's a mistake.
Even if it's undisputed, that my promotion was based on seniority cum fitness, but still they see the parameters. But what it says is that if I am promoted on merit, you can't look into anything else. But since I am on seniority cum fitness, you can look into it. But what you can look into? Only something which is only adverse against me, both good and both bad. And then you have to take a call, my lord. This is the decision-making process.
Mr. Dubey, what is the date of birth?
My lord, will find at page 20, my lord, in the order of compulsory revision, 5/1/1996, 1966.
Page 20.
Yes, yes. First annexure 1.
5/1.
5/1/1966.
66. 60 years will be in 2026.
January 26. Okay. In the record also, they don't have anything adverse against me. They say they can rely upon, but they have not relied upon any adverse communication because I have been given that liberty to peruse the record, my lord. And whatever there in the affidavit, it based on records only.
Okay. Close the matter. Or Monday, you said you'll produce on Monday.
Monday.
Okay. Please, right? This parties have completed their submissions. But however, the respondent FCI needs to produce the relevant material / record which provides for promotion by 2 methods, that is promotion based on seniority cum merit and promotion based on seniority cum fitness. List again on Mondays. 24th. List again on 24th. That's part time.
I'm sorry, my lord. There is one clarification. Your lordships on the other day has asked why this financial and or there is one circular by FCI which says from 22 onwards it has been made rather than a calendar, my lord, it's been made financial year.
Okay, this is the financial year.
Yes, from 22 onwards.
Prior to that, it was calendar.
It was calendar.
Calendar year.
And that's why your lordship has seen 31st March, 1st April, my lord. And it is automatic, my lord. Even if I don't submit mine, my lord, they have to do their part, which they have not done.
This now says what? Calendar year? No, financial year.
Financial year.
My senior name may kindly be reflected, my lord. The orders.
Is item 25, isn't it? Beginning right, heard Mr. R. Dubey, learned counsel for the petitioner, and Mr. K. M. Chaudhary, learned senior counsel. Assisted by Mr. BKC for the respondent FCI. Then you can continue with the remaining.
I was to produce the record, my lord. The record is in digitalized form. I have brought all the relevant papers, my lord, with the index, my lord. It has been paging it, my lord. Yes, submit, my lord.
This is about photocopy.
Yeah, yes, my lord. The records are all digitalized, my lord.
Digitized.
So may I submit, my lord, from the index, my lord? First of all, the on 19/8/2016 memo was issued to the petitioner, my lord. Thereafter, on 7/9/2026, that is at page 22, my lord. The petitioner sought time to submit her reply.
Page 22.
Page 22, my lord. From
So
page to page 1 to 21 is the memorandum of charges.
I see.
So again, the memorandum of charges, the last paragraph, hence I request you to grant me at least minimum 90 days for replying the memorandum served upon me by you so that I may be able to give an appropriate reply regarding the matter.
Yes.
On the next page, my lord. 23. It's an inter-office letter, my lord, wherein the written reply of the petitioner was submitted, my lord, forwarded. So page 24, my lord. The page is hazy because, my lord, I've been told that after the getting it typed, the petitioner has taken a photograph and then it was sent to the via mail to the FCI office. That's why, my lord, in this condition. May I read the written reply, my lord? I am to state that, kindly refer to above, I am to state that I do hereby deny all the charges framed against me by annexure 1, 2, 3, and 4 of the memorandum. Under the reference, as I discharge my duties as assigned time to time. On 16/5/2016, a statement was submitted to JADO any vigilance team as desired by RO Itanagar on request of JADO vigilance team. There I expressed my desire to be heard in person at JADO any vigilance so and so. And for the second time on 7/7/2016, I have communicated to the FCI headquarter New Delhi, that I should be heard in person. So by this written reply, she has denied all the charges.
What is the date?
Date is, my lord, it's 16/10/2016, my lord, 26/10. 26/10/2016. Thereafter, my lord, on 24/11/2016, appointment of inquiry officer was made. That is page 25 and 26. And then again, on the same date, appointment of presenting officer. Then, my lord, at page 28, petitioner was directed to report for preliminary hearing to be held on 25/7/2017 and 26/7/2017. Page 28, my lord. Subject preliminary hearing regarding departmental inquiry. It was sent via mail, my lord, and also at the next page, the latter also was forwarded. Second paragraph, the preliminary hearing in respect of Ponung Moyang B, then area manager B.O. Bandardeva under R.O. Itanagar, under deputation from Government of Arunachal Pradesh while functioning as area manager of District Office Bandardeva with effect from 30/9/2011 to 16/3/2016 is scheduled on 25/7/2017 and 26/7/2017 at FCI R.O. Gauhati Conference Hall at 11:30 hours. So preliminary hearing was when it will be conducted, it was informed to the petitioner, madam. Then page 30, the minutes of the preliminary hearing. Page 30, madam. Preliminary hearing in respect of Srimati Ponung Moyang B, then area manager. Number 1. At the outset, inquiry officer asked the charge officer as to whether the charge sheet and supporting documents have been received. The charge sheeted officer informed that she has received the charge sheet. However, she could not confirm as to whether all the supporting documents have been received and assured to inform the same after verification before the next date of hearing. My lord, this is important. Number 2, IO further inquired whether the charge officer is ready to accept the charges. The charge of CO denied the charge. Number 3, subsequently, inquiry officer asks whether the charge sheet officers will be engaging a defense assistant to plead her case. In this regard, the charge sheet officer informed that a defense assistant would be engaged to plead her case, and the consent letter of the defense assistant would be brought for the next date of hearing. The charge sheeted officer has also informed the IO that she has not received any permission from the government of Arunachal Pradesh till date, that is 25/7/2017, and the charge officer informed that in the honor of the letter of the IOC has reported the preliminary hearing today on 25/7/2017. Number 4, inquiry officer informed that the next date of hearing is on 2/8/2017 and 3/8/2017 at 11 hours. Inquiry officer advised charge officer that the process of engaging defense assistant and obtaining permission from the competent authority for engaging defense assistant be completed well before the next date of hearing. It was resolved that the disciplinary authority be informed of the lack of permission from the controlling office of the charge officer for urgent necessary action at their end. Further, IO informed that the requisition for documents and witnesses be submitted before the next date of hearing to facilitate early completion of inquiry process. Then signature of the charge officer, my lord, and the presenting officer and the inquiry officer.
She had attended the preliminary hearing.
Yes, my lord. She has put her signature also, wherein she has stated that she has got the document, but she has to confirm whether all the, after verification, whether before the next date, whether all the documents are available with her or not. That is at point number 1. As fixed on 2/8 and 3/8, my lord, that day it could not be held, so it could not be held because of the inquiry officer was in some tax audit, my lord. So it was informed to the petitioner. That is page 31, my lord. July 20, my lord, page 31. July 27, 2017. With reference to your mail regarding inquiry proceeding in which Gaurav Pawar is presenting officer, Sri Gaurav Pawar is presently looking after taxation issues as well as the accounts due to the implementation of GST with effect from so and so. There are several time-bound tax compliance issuance of GST period as well as per the GST period which are coming up now and then closing. Down below then in last three line. In view of the above cited reason, it is not possible to spare Sri Gaurav Pawar for scheduled date of hearing on 2/8/2017 and 3/8/2017. It is requested to postpone the scheduled hearing dates and the date may be fixed on 4th week of August 2017. So, on the next page 32.
This is a communication to whom? From whom?
It is from Assistant General Manager, Finance and Accounts, to the FCI Assam and General Manager Finance Northeast.
No, page 31, page 31.
Page 31, my lord. Then upper part, my lord, original message from Assistant General Manager. Subject resettlement of the hearing.
From Assistant General Manager.
Assistant General Manager, Finance and Accounts, FNA.
Written to whom?
It was, my lord, inter-department, my lord. From Zonal Office to the Regional Office, GMAS, to FCI RO Assam, and copy to General Manager Finance Northeast. So my next page, the date of hearing was rescheduled on 24/8/2017 and 25/8/2017. May I read it, my lord? Last three lines. The next date of hearing is fixed on 24/8/2017 and 25/8/2017. You are kindly requested to do the needful before the next date of hearing for early completion of inquiry proceedings. It was from the inquiry officer communicated to ED notice drawn. So petitioner was also informed about the rescheduled date. So on the date of inquiry, my lord, page 33.
No, just a minute. I'm in 32.
Subject is regular hearing regarding departmental inquiry under regulation 58 of FCI. She has informed that she has not received any promotional government till date, and the charge officer informed that the honor of being she has reported for payment.
Inquiry officer has written to whom? Executive Director?
Executive Director.
For what? Giving the date, next date.
Yes, madam. And to do the needful in this regard.
Needful means what?
Maybe while communicating to the petitioner.
PO and CO.
Inquiry officer. So on the next date, my lord, subject send a mail from the petitioner. Subject unable to attend the hearing regarding departmental inquiry fixed on 24/8/2017. So this mail was received on 24/8, my lord, on the date of hearing on. Sir, I am to inform you that I will not be able to attend the above mentioned inquiry on scheduled date, that is 24/8/2017 and 25/8/2017 due to enrollment of Aadhaar card for Dulari Kanya scheme and Pradhan Mantri Matru Vandana Yojana, which is a very important scheme directly related to the central government. So I am unable to attend. Kindly consider my absence. It was informed to the RO Assam, Regional Office Assam, and with a copy to the inquiry officer. Then my lord, next page.
Page 33, email was sent on the same day.
On the date of hearing, my lord, 24/8. The
24/8.
date is 8/24/8, that is month. 24 is the date and 17 is the year.
It's in the evening, 5:59 PM.
5:59 PM.
Hearing was fixed at what time?
Usually, my lord, 11 AM.
Timing is not
But
given.
no hearing taken place on that day, my lord.
Sorry,
No hearing was taken place on that day.
obviously, she has not come.
Yes, my lord. Notice of next hearing. May I read it, my lord?
I've read it. Now timing is given, 11:30.
Yes, 26/10 and 26/10/2017 and 27/10/2017 at 11:30 hours.
Earlier, there was no time. Then,
Then next page, page 35. Again, on the email dated 26/10/2017 at 11:23 AM. I am to inform you that I will not be able to attend the notice of next hearing as I am preoccupied with the office work for which my personal presence is a must. And page 36, madam, an important letter dated 19/12/2017. A letter by the inquiry officer to the petitioner. Subject final hearing on 29/12 and 30/12. With reference to the subject cited, it is informed that the FCI headquarters has comments adversely on the delay in completion of inquiry proceeding and have instructed to complete the hearings on day by day basis. Accordingly, you are requested to attend the final hearing proceeding on 29/12/2017 and 30/12/2017 at 13 hours. 11:30 hours at the chamber of the undersigned. Further, the following mentioned below PWs are requested to attend the same on the above mentioned date and time accordingly for final completion of the case. So 1, 2, 3, 4, these witnesses' name. In case charge officer fails to appear at the appointed date and time, proceedings will be taken ex parte. What should be 19/12/2007. This time, 1 day prior, mail was received by the department, page 37 by the inquiry officer. Sir, may I read it, madam? Page 37.
yes, read.
Sir, I am in receipt of the letter dated 27/12/2017. I am to inform you that I am on medical leave, will intimate after my join.
It should be intimate.
Yes, intimate, yes, madam, not intimidate.
Intimidate. Then,
The next page. received again at 10:24, or the first one was received at 11:12. Same thing, will intimidate after joining. Then page 39, my lord, the date of hearing.
39,
39,
date of hearing.
date of hearing, 29/12/2017. In pursuant to the order conveyed by letter dated 21/12/2017 as Sri S.K. Pramnik, PW1 and Sri Gaurav Power EO reported for hearing on date. CO namely Panung Mayung via email dated 28/12/2017 has informed that she is in receipt of the order, and as she is on medical leave, she is unable to attend. In this regard, attention was drawn to the FCI headquarters letter dated so and so, wherein it was conveyed that the inquiry proceeding henceforth be conducted on day-to-day basis, and it's already been very badly delayed. Accordingly, IO has instructed that the deposition of PW may be taken and may be done by PO today. Thereafter, the deposition commences as under. The following reports were placed on record by the PO along with the enclosures and exhibited as follows. Examination of Sri Pramanik. So page 39, 40, 41, 42 examination was done. Page 42, the down below my lord. My lord will come to page 42 after the end of the examination. The deposition is completed and IO informed that the copy of the deposition would also be sent to the CO for record. It is also decided that the next date of hearing would be conducted on 10th and 11th January 2018. And
So this was not final hearing then.
yes, ma'am, the first witnesses was recorded, examination of first witness. Then page 43. So next date was fixed on 10/1/2018 and 11/1/2018 was informed to the petitioner. Again, the last line, in case charge officer fails to appear at the appointed date and time, proceedings will be taken ex parte. So on that day, 10/1/2018, my lord, 3 witnesses were examined from page 44 to 45. Jai Prakash, the then DGM. Then page 46, Amit Kumar Singh, AGM accounts. Then page 48, Nitin Khurana, AGM. So my page 50, the deposition was forwarded to the petitioner with the next date of hearing, informing the next date of hearing, page 50. Page 50, ma'am. May I read it? Please refer to this office dated 31/3/2018, wherein it was informed that inquiry proceedings will be scheduled on date. It has been observed, in spite of the same, you have not attended the proceedings. As informed earlier, the inquiry proceedings were conducted wherein the PO examined PW, namely Nitin Khurana, Amit Kumar Singh, and Jai Prakash, so and so. Copy of the proceedings are enclosed for time perusal. Further hearing scheduled on 23rd and 24th January 2018 at Vigilance Divisions, first floor, FCI headquarters, Barakhamba, New Delhi. So my next page 51, on 23/1/2018, one Mr. Inder Kumar Negi was examined, my lord. It was done at headquarters, my lord, because I think the petitioner that witnesses was from Delhi itself. Then at page 52, again, the petitioner was informed the next date of hearing, that is on 2nd and 3rd February 2018. And this proceeding was also sent to her. Page 52, madam, the notice. Informing that the next proceeding will be on 2nd and 3rd February. So your lordship will find page 54, the proceedings, the examination of the last witnesses, Asung Naglum, Manager General, page 54 to 55. So by page 56, my lord, by this 5th February 2018 mail, the proceedings of the last date was informed to the petitioner, madam, with a copy of the examination of Asung Naglu. Then, my lord, came inquiry report, page 59. 59 to 65. So this inquiry report was forwarded to the petitioner, my lord, by page at page 66. With a request to make a representation or submissions against the such inquiry report. Page 66. May I read it, my lord? Page 66. The report of inquiry is enclosed. The disciplinary authority will take a suitable decision after considering the report. If you wish to make a representation or submissions, you may do so in writing to the disciplinary authority within 15 days of the receipt of this letter. This was on 19/3/2018. Then again on 1/5/2018, the petitioner was again informed, page 67. This is a letter by the manager vigilance to the CDPO where the petitioner was working, my lord, page 67. To the director. You are requested to first serve the inquiry report dated 14/3/2018 upon so and so against the dated acknowledgement receipt for forwarding the same to this office so that the same can be forwarded to FCI, Gauhati, for information and necessary action. This may be treated as most important as the same matter has also been investigated by CBI and desires the action taken by the FCI against the delinquent. Then a letter was forwarded to the FCI, my lord, by the government of Arunachal Pradesh Women and Child Development. 21st June 2018, page 68, my lord, forwarding the acknowledgement of the petitioner that she has on receipt of the inquiry report. Page 69 is the acknowledgement. Then, my lord, again on 28, 2018.
Yes.
The subject is furnishing a reply from Srimati so and so against the IO report dated 14/3/2018. With reference to the subject cited above and the communication dated 16/8/2018 from FCI Headquarters Regional Division, wherein it has been directed to pursue the matter with your office in order to get the reply from the Ponung Moyung, the then area manager P.O. Bandardeva by 25/8/2018. In this regard, it is to inform that the said communication has already been transmitted to so and so via mail as her personal ID number on 17/8/2018 at so and so hours. However, till now, the headquarter directives, you are requested to kindly intimate the so and so to furnish her reply within 25/8/2018 against the IO report dated 14/3/2018. which has been received by her on 17/5/2018 as per dated acknowledgement. Srimati Ponung Mayung may also be informed that on failure to furnish the reply within 25/8/2018, the said case will be processed without further delay by the FCI headquarters. So, my lord, when this reply was not received by the FCI, my lord, then by letter dated 9/1/2018, that has been annexed in, I have not annexed, my lord, here. That has been annexed by the petitioner in his writ petition. That is the impugn letter they have challenged.
Which one is that?
Page 80 of the writ petition, my lord. Request to take action against Ponung the then area manager absent. It was written to the Chief Secretary Government of Arunachal Pradesh, my lord. Since the penalty would be the major penalty, so and as such the parent department will take action as per the law, my lord. So in this letter, detailed article of charges and the findings were quoted, and thereafter at last page 93. Page 92, my lord. Last paragraph. In view of the above facts and circumstances narrated, and on the basis of the documentary evidence submitted by the inquiry officer, presenting officer, all the articles of charges mentioned in the memorandum dated 19/8/2016 are proved, and it has been established that so and so the then area manager FCI Bandedeva is solely responsible for such huge financial loss to the corporation, and due to which the FCI has suffered a huge avoidable financial total loss amounting to rupees 86.38 crores. And page 93. And therefore, as per the FCI regulation 1971, regulation 65(2), Roman 2 and CVC Vigilance Manual 2017, and the chapter 23 of the Handbook of Inquiry Officers, all the relevant documentary reports of memorandums, along with the article of charges, finding, observations, conclusion of the inquiry officer, B. Devanand, DGM, and other related annexes, paper enclosed, are being forwarded to the state government with the request to impose strict penalty upon the Ponung and then area manager FCI Bandedeva for such irregularities, fraudulent payment, misappropriation of stocks, due to which FCI had to suffer a huge avoidable financial loss amounting to rupees so and so. In case any clarification is required to enable the competent authority to take decision in the case, then an officer and from the FCI can be deputed to explain the same. So, my lord, it has been seen from the record that the principle of natural justice has been fully followed by the FCI, giving every opportunity, giving all the details of the proceeding of a particular day, informing to the petitioner, and also informing that the next date of hearing is such and such date. But petitioner choose not to not to appear and not to participate, my lord, on this plea or that plea. The government of Arunachal Pradesh will say that the permission was given to the petitioner to participate, my lord. But however, the petitioner has chosen not to participate, my lord. Now they have come up with with this present writ petition challenging the inquiry report and this letter dated 9/1/2019, issued to the Secretary Government of Arunachal Pradesh to take action as per the law. My lord, on the first day, I have argued that the proceeding has not been concluded, my lord. Proceedings will be concluded only when the disciplinary authority will accept the inquiry report and may take or may not may not take any action. I mean to say, and may not impose any penalty, my lord. now the ball is before the disciplinary authority, my lord, to take action. And the petitioner will obviously get another chance to appear and to give a representation against the inquiry report. Petitioner will be heard by the government of Arunachal Pradesh before taking any action. So in this regard, I want to rely to judgment, my lord, wherein I want to say that the proceeding has not been completed, my lord. It is a premature, my lord, writ petition, my lord, because the petitioner has chosen not to participate and not to contest the disciplinary proceeding. Now at this stage, she cannot come and now challenge this proceeding. Let the proceedings be completed. Let the disciplinary action be disciplinary proceedings be concluded, my lord. I would like to rely on 1998 7 SSC page 84.
Supplied the list of books.
Yes, my lord, I am supplying. Punjab National Bank versus Kunj Bihari Misra.
This is regarding.
My lord, the charge sheet was challenged by. So paragraph 18, my lord, at page 9. Paragraph 18. 1998 7 SSC page 84. May I read it, my lord? Under Regulation 6, the inquiry proceeding can be conducted either by an inquiry officer or by the disciplinary authority itself. When the inquiry is conducted by the inquiry officer, his report is not final or conclusive, and the disciplinary proceeding do not stand concluded. The disciplinary proceedings stand concluded with the decision of the disciplinary authority. It is the disciplinary authority which can impose the penalty and not the inquiry officer. Where the disciplinary authority itself holds an inquiry, an opportunity of hearing has to be granted to him. By him. When the disciplinary authority differs with the view of the inquiry officer and proposes to come to a different conclusion, there is no reason as to why an opportunity of hearing should not be granted. It will be a most unfair and iniquitous that where the charge officer succeeded before the inquiry officer, they are deprived of representing to the disciplinary authority before the authority differs with the inquiry officer's report. And while recording a finding of guilt imposes punishment on the officer. In our opinion, in any such situation, the charge officer must have an opportunity to represent before the disciplinary authority before the final findings on the charges are recorded and punishment imposed. This is inquiry to be done as per the part of the first stage of the inquiry as explained in the Karunakar's case. My lord, after the inquiry officer has been report, a chance was given to the petitioner that you can make a reply, my lord. She has not taken any steps, man. Now she has come challenging the inquiry report and that letter issued to the government of Arunachal Pradesh. So what I want to submit, my lord, let the proceedings be concluded, my lord. Let the disciplinary proceeding authority take the action, my lord. May not accept the inquiry report also, and further, my lord, the petitioner will get a chance before the disciplinary authority also, the government of Arunachal Pradesh, to represent her case again, my lord. So in this line, another judgment I want to rely, your lordship, that is Union of India, Puni Setti Satyanarayana, reported in 2006, 12 SLC, page 28. Page 28. Para 13, 14, and 16. Paragraph 13, 14, and 16.
This is on which point?
Para 13, same, my lord, except petition is premature, my lord, let the, this proceeding be concluded, my lord. 13, 14 and 16, my lord. Para 13.
Yes.
It is well settled by a series of decisions of this court that ordinarily no writ lies against a charge sheet or surplus notice, right? Executive engineer so and so. So this is a well settled proposition. Number three, para 14. The reason why ordinarily a writ petition should not be entertained against a mere surplus notice or charge sheet is that at that stage the writ petition may be held to be premature. A mere charge sheet or surplus notice does not give rise to any cause of action because it does not amount to an adverse order which affects the rights of any party unless the same has been issued by a person having no jurisdiction to do so. It is quite possible that after considering the reply to the surplus notice or after holding an inquiry, the authority concerned may drop the proceedings and or hold that the charges are not established. It is well settled that a writ lies when some right of any party is infringed. A mere surplus notice or charge sheet does not infringe the right of anyone. It is only when a final order imposing some punishment or otherwise adversely affecting a party is passed that the said party can may be said to have any grievance. So, my lord, I am heavily relying on this. Because the petitioner has chosen not to participate in the disciplinary proceeding. Para 16. No doubt in some very rare and exceptional cases, the High Court can pass a charge sheet or surplus notice if it is found to be wholly without jurisdiction or for some other reason, if it is wholly illegal. However, ordinarily, the High Court should not interfere in such a matter.
That precisely is the case of the petition, I think.
Yes, my lord. But she has chosen not to participate, my lord. Let what I am submitting, my lord, let the proceedings conclude, my lord.
No.
She will not participate and one fine day she will come. No.
I don't mean about the conclusion. She is challenging the jurisdiction.
Jurisdiction, I am coming, my lord.
Of challenging, I mean, of drawing the proceeding. She is a employee of the government of Arunachal, and then as an FCI, you have to doing the proceeding. So she has already been repatriated. So that's why.
No, my lord.
This is what they have said.
After being charge sheeted on 19/8/2016, she was repatriated.
So,
But
I mean,
before that, the proceeding has initiated. Proceeding has initiated after the issuance of the memo of charges, my lord.
so make your submission on that.
Yes, my lord.
That it is permissible to do so.
The other day, your lordship wanted to see the I've taken only the relevant piece from the handbook for inquiry officers and disciplinary authorities, my lord. Regarding borrowed and land officer.
You have given a handbook. So you have given a handbook, correct?
No, my lord, I have just taken a printout of the relevant page. My lord. Before that, your lordship will take that IA application 3609 of 2023, wherein I have quoted the relevant
is for what?
IA for vacation of the interim order matter.
I see.
Matter was pending. Page 15, para 31 first.
Page?
Page 15, ma'am.
Yes.
Para 31, that the above letter dated 9/1/2019 has been issued by the FCI headquarters New Delhi in accordance with the provisions contained in Regulation 65 2 Roman 2 of the FCI Staff Regulation 1971 and CVC Vigilance Manual 2017.7.4 and Chapter 23 of the Handbook for Inquiry Officer and Disciplinary Authorities issued by the Government of India, Department of Personnel and Training, Ministry of Personnel. That Regulation 65 has been quoted, my lord.
This letter 19/1/19, what is this?
19/1, where after the inquiry report, my lord, after waiting for the petitioner's representation, when it didn't came, then we have given to the government of Arunachal Pradesh to take action as per the law, my lord. Page 17, my lord, the Roman 2, subclause Roman 2, my lord, page 17. If the discipline.
Page 17.
Yes, ma'am. That first paragraph, if the disciplinary authority is of the opinion that any of the penalties specified in clause 5 to clause 9, regulation 54 should be imposed, that is relating to the imposing major penalty imposed on him, it shall be replace his service at the disposal of the landing authority and transmit to it the proceedings of the inquiry for such action as it may deem necessary. So the disciplinary authority has found that it has major penalty has to be imposed, so it was sent to the government of Arunachal Pradesh at their disposal, madam. Then para 33, the 0.7.4 of the CBC Vigilance Manual 2017 is extracted as under. Authority is competent to initiate disciplinary proceeding against officers lent or borrowed by one department to another or state government, etc. For the powers of the authorities to deal with the misconduct committed by an employee borrowed from another organization and the procedure to be followed in such cases refer to Chapter 23 of the Handbook of the Inquiry Officers and Disciplinary Authorities issued by the DOPT. So this CBC Vigilance Manual say that it has to be followed as per the Chapter 23 of the Handbook of Inquiry Officers. That has been quoted, my lord, there. So Chapter 23, borrowed and lent officers. It has been summarized in point number 5. Briefly, what are the powers of borrowing and lending authorities? Power of borrowing authority may be summed up as under. It can suspend but should report the matter to the parent department. It can initiate disciplinary proceedings. It can impose minor penalty subject to the consent given by the parent department. It will have to repatriate the employee if it is of the opinion that the major penalty is required to be imposed. Findings of the inquiry conducted by borrowing department are not binding on the lending department. Lending authority is at liberty to conduct further inquiry as deemed necessary. So, my lord, I am saying that it is upon the lending authority whether to impose penalty or not with us, my lord. So let this be concluded, my lord. come to a reasonable conclusion, my lord.
See, regarding the repatriation, what was the hurry in repatriation? Did you address that last time? What was the hurry in repatriating?
I have not found.
There was some reason last time.
Because she has done, I mean, that can be assumed only. She has done enough of this thing. So it has been, it was first of all transferred to the JADO at Gauhati. Thereafter, she was repatriated to her parent. And my lord, only last, I want to rely on BC Chaturvedi's case. my lord.
Repatriation was on request.
Repatriation.
Repatriation was on request, or you had repatriated like that?
We have repatriated.
Because that time that DP was not completed.
No,
Of course,
just
till
it
now
was-
also is not completed.
No, my lord. It was, we have issued the memo of charges on 19/8/2016 and was repatriated on 29. Annexure?
29.
Yes, a copy of the officer 29 relieving the, yes, my lord, it is there, page 54 of the.
Suspended on 24/5/16. Repatriated on 20 of September 2016.
And relieved on 21/9/2016.
Memo of charge just before that,
Yes.
on
Yes, sir.
19/8/2016.
Just the previous date.
No.
1 month before.
Memo of charges was on 19/8.
Yes,
He's wrong.
19/8.
1 month.
19/8.
And it was on 29, after 1 month, 2 days, 1 day.
1 month before.
But the inquiry officers were appointed after repatriation.
Anything else, Mr.
Only BC Chaturvedi's case, my lord, I want to rely. 1995 6 SSC 749. Para 12, my lord. BC Chaturvedi's law. Then.
This is regarding
I will take judicial review, my lord.
judicial power.
Yes, ma'am.
Okay, scope of judicial review.
Yes, ma'am. Para 12.
Yes,
Page 4.
yes.
Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or whether the rules of natural justice are complied with. Whether the findings or conclusions are based on some evidences, the authority entrusted with the power to hold inquiry has jurisdiction, power, and authority to reach a finding of fact or conclusion. But that finding must be based on some evidence. Neither the Technical Rules of Evidence Act nor the proof of the fact or evidence as defined therein apply to the disciplinary proceedings. When the authority accepts that the evidence and the conclusion receive the support therefrom, the disciplinary authority is entitled to hold that a delinquent officer is guilty of the charge. The tribunal, in its power of judicial review, does not act as an appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court tribunal may interfere when the authority held that the proceeding against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribing the mode of inquiry, or whether the conclusion or finding raised by the disciplinary authority is based on no evidence. If the conclusion or finding by such as no reasonable person would have ever reached, the court may interfere with the conclusion or finding and mold the relief so as to make it appropriate to to the facts of each case. So, my lord, again, I'm repeating, my lord, natural justice has been followed, my lord. The petitioner has chosen not to participate in the disciplinary proceeding. Each day of hearing was intimated to the petitioner, my lord, and also the next date of hearing, my lord. So that is my humble service. And let the disciplinary proceeding conclude, my lord. Obliged, my lord.
Yes, Adhikari.
Yes, my lord, may it please also, we have filed our affidavit, my lord. I will take a lordship to 2-3 paragraphs of my affidavit, my lord. 11, 14, 11, 14 and 16. The affidavit filed by responding number 5, 6 and 7.
Give me the page.
Page number, my lord. Come on, affidavit is also.
5, 6 and 7.
Yes,
Okay. You don't have a running page with you.
you know.
I will provide it.
It starts from 95.
Para 11.
Running page starts from 95.
97, my lord.
Yes, my lord, here, my lord, what we have stated is, my lord, there was an allegation that order placing suspension was not, my lord, was not made available to us. Now here, my lord, we have, what we have stated, also we kindly see,
Paragraph.
11, page 99.
97.
97, sorry, my lord. The statement made in paragraph 14 of the deponent denies the same, states that the order of placing the petition under suspension has been duly submitted to the lending department of so and so, my lord. Deponent doesn't admit anything which are contrary to records. This is one. Then also may kindly see, come to next page, my lord, paragraph 14. Well, regarding, my lord, the appointment of inquiry officers by the state, my lord, here is our reply, my lord. With regard to the statement made in paragraph 19 of the writ petition, your deponent states that petitioner submitted a representation dated 7/1/2017 for appointing an inquiry officer and presenting officer from our current department. But before the submission of the representation by the petitioner, the Food Corporation of India Authority had already appointed inquiry officer and presenting officer and forwarded the copies of the order number so-and-so dated 24/11/2016 and order number so-and-so dated 24/11/2016 for causing service upon the petitioner. So, my lord, even before, my lord, she represented for, my lord, appointment of presenting officer and inquiry officer by the state, my lord, the FC had already appointed the presenting officer and the inquiry officer. This is what I wanted to point out. Then 16, my lord, para 16, the next page. With regard to the statement made in para number 21 of the writ petition, your deponent denies the same. It states that Rule 20 of the CCA rules stipulates that the borrowing authority shall have the powers. But here it was said the borrowing department has no authority for the purpose of conducting disciplinary proceeding. Here we have stated that under Rule 20 of CCA Rule 965, the borrowing department has the authority to initiate departmental disciplinary proceedings against the officers borrowed from another department. This is what I wanted to point out, the 3 paragraphs.
Paragraph 16. Just read that again.
Yes. Well, para 16, my lord. With regard to the statement made in para 21 of the writ petition, your deponent denies the same. It states that Rule 20 of the CCS, because well, here we have adopted, in the statement we have adopted CCA Rule 965 for disciplinary matters, my lord. It stipulates that the borrowing authority shall have the powers of disciplinary authority for the purpose of conducting disciplinary proceedings against the officers borrowed from another department or other authorities. As per the order dated 24/11/2016, the inquiry was ordered solely against the petitioner, Srimati Punu Mayong, and not inquiry against group of persons, common proceedings as contended by the petitioner. Further, the deponent doesn't admit anything which are contrary and inconsistent with the responsibilities. Now, the inquiry, the proceedings of the inquiry has been furnished to us. We are yet to act on it because in the meantime, on
There's a stay order.
yes, 24/5/2019, there's a stay. So we are yet to state is yet to apply its mind, If we don't agree with the findings of the inquiry officer, we remit the matter back to the FCI for further inquiry.
That's all.
All right.
Before I answer to the argument of the FCI council, just may I point out two, three things as argued by the state council. Lordship, may have a look at paragraph 16, which is in reply to our paragraph at 21. Now, in that paragraph, we question the holding of a common inquiry, and my lord, we are not pressing that point here. So this reply 16 is of no consequence. Lordship may have a look at paragraph 21 of our writ petition. In what context this paragraph 16 has been replied to? Because we had taken a point that common inquiry could not have been conducted against the petitioner and the FCA employees under the FCA. Page number 11, my lord. In the context of our statements made in paragraph 21, this paragraph 16 has come. So we are not argued on this line, my lord, here before your lordship. The petition begs to state that regulation 62 of FCI staff regulation stipulates one, where two or more employees of the corporation are concerned in any case, the board. So it is a case where we were arguing or we had taken up a point that a common inquiry was held, where the petitioner as well as the employees of FCI were included together in one inquiry. But now we are not pressing. So in that context, that paragraph 21 is, paragraph 16 is there. But so far paragraph 11 and 14 are concerned, my lord. If your lordship takes up the FCI regulation, which we had given on that day, I had given the printouts.
Number?
65. FCI regulation 65.
Yes.
Now, provision regarding officers borrowed from central government or state government owned organization, companies and corporations. Now, one, where an order of suspension is made or disciplinary proceedings are taken against a government servant or an employee of a public sector or private sector undertaking whose services have been borrowed from government or an authority subordinate thereto, or such undertaking, the authority lending his service, hereinafter referred to as the lending authority, shall forthwith be informed of the circumstances leading to the order of his suspension or of the commencement of the disciplinary proceeding. Now, here we'd like to say that it is not just a communication of the suspension order or a charge sheet. It is something more than, because shall forthwith be informed of the circumstances leading to suspension or departmental proceeding. So here they are saying that they have received a copy of the charge sheet and the suspension letter. The language is very clear. It is the rule-making authority did not confine it to the communication of that letter of suspension or the charge sheet. It is something more than that. Shall forthwith be informed of the circumstances leading to the order of suspension. So here what they are saying, we have received the suspension order or the charge sheet, so it amounts to compliance. But it is not, man. The rule is something more than that.
What is the purpose?
That is there in the rule, my lord, because ultimately, my lord, it is the disciplinary authority is the temporary disciplinary authority. The main disciplinary authority will always be the lending department. That is why the rule says that forthwith communicate the circumstances leading to the imposition of or issuance of the suspension order or the disciplinary authority. So in that context, so here lordship will see they have agreed, and it is not our case that it was not communicated. It is communicated, but it is not the way it ought to have been done. The rule is it says it shall be forthwith forwarded to the lending authority about the circumstances leading to suspension or disciplinary proceeding. Now, my lord, since the state of Arunachal Pradesh has not yet taken any action, so I'll just now reply to what the FCI Council has submitted. My lord, the FCI service regulation is very clear that the FCI authority can initiate a departmental proceeding. But my lord, there is nothing in the rule which they could show that the initiation of the inquiry can be continued after the repatriation. Because if your lordship takes up the rule 65, it says once it is initiated, then the inquiry will conclude till a question of imposition of major penalty comes, and in that case, the person will be repatriated. Again, lordship may have a look at rule 65.
So the same question I had asked, why repatriation was in a hurry?
They have.
You had asked for repatriation.
No.
After suspension, you were brought here to Gauhati, and from here you were sent back.
Yes. So
that was
why,
as per your request, or what was the reason behind?
That instruction I do not have.
Not that. Okay.
But the fact remains, my lord, it is always the prerogative of the borrowing department whether they should keep it, they should keep the employee, or they will send it. Now they have admittedly repatriated me.
But that is the point you want to make right now, saying that as per the regulation, once the everything is over, then you can send me back, and with along with whatever inquiry report, if they ultimately intend to, you feel that you should be imposed with a major penalty. But here's a case wherein after the inquiry, what you call the memo of charge was given, then you were sent back.
Yes.
Then inquiry continued. Whether that is
After the inquiry officer appointed. Now here I would like to urge one thing, my lord. The disciplinary authority in the borrowing organization remains a disciplinary authority and discharges the power and jurisdiction on the basis of the powers given under the rules. The disciplinary authority cannot act beyond the rules. Here, the question is, once you repatriate me, you lose your jurisdiction over me to go ahead with the inquiry. Now, once the jurisdiction is there, not there, then how the inquiry officer can be appointed and how the inquiry officer can discharge the functions of an inquiry officer under that rules. Now, the rules does not say anything as to how the inquiry, even after it is initiated, will continue after repatriation. The rules nowhere says or authorize empowers the disciplinary authority to continue with the inquiry or appoint an inquiry officer and take.
What happened to your suspension?
Suspension was revoked.
Revoked on
Yes.
your repatriation?
Yes, my lord.
Or before the repatriation?
My lord.
Before the issuance of the charge name.
Okay. On the same day on which my lord, the suspension order was revoked on 19/8/2016, on the day the charge sheet was issued.
Okay, while you were here.
Yes.
While you were with the FCI, at that time
Yes.
it was revoked.
It
charge
was
sheet given.
revoked, charge sheet issued on that day, both by separate order. After 1 month, repatriated. So, my lord, I'm questioning the jurisdiction of the disciplinary authority of FCI to go ahead with the inquiry after.
Do you have any authority in that?
My lord, on the last day, I submitted that judgment of FCI and a Madhya Pradesh High Court judgment, which says that after repatriation, inquiry cannot be done because the employer-employee relationship comes to an end. My lord, that decision 2003-11 SCC 508. In that case, the question was different, my lord. The BSF employee, a police personnel, deputation in BSF, and then repatriated. Then a question arose whether he should be proceeded under the BSF Act or the police department rules. He wanted to say that since the offense was committed while I was in BSF, so I am covered by the BSF Act. But the Supreme Court held that no, once you are repatriated, you no longer remain a subject of the BSF Act. So the BSF Act and rules will not apply. Similar is the case here, where I, an employee of the state government in FCI on deputation and then repatriated. So with my repatriation, the rules and regulation of FCI will not apply. And based on this judgment, my lord, there's another judgment which I had given on that day. PL Satyarthi versus State of Madhya Pradesh is the division bench judgment of Honorable Madhya Pradesh High Court.
Yes, para 7.
Yes. Paragraph 7, yes. Paragraph 7. ये legal का है. So, if your lordship holds that the disciplinary proceeding initiated or commenced by appointing an inquiry officer and presenting officer by the FCI department under the FCI regulation is bad, then the whole inquiry goes. So this is the broader aspect. Even, my lord, if your lordship takes up the FCI regulation, না ওটা আমি ফটোকপি করে এনেছিলাম।
Regulation number?
Regulation number 58, my lord, I made a photocopy. It would be
58. Fifty-eight.
58, it is not there, my lord. I made
It's not there.
Yeah.
So
Page number 44. Page number 44, regulation 58. I had made a photocopy, my lord. It would detail motatum. Lordship, I have given a photocopy of regulation 58, page number 44. It will be easier for you, lordship, to find.
it's page 41.
Page 40. I have given that.
This is 41.
Page 44. Regulation 58.
58 is 41 in your compilation.
I have given that. 41.
It's 41. This also is 41.
And regulation 23. What 58, 23. Page number 46. Now, that day I pointed out and cited certain some Supreme Court decision. Here also the FCI regulation says, after the conclusion of inquiry, a report shall be prepared and it shall contain, among many other things, D, the findings on each article of charge and the reasons therefor. And if your lordship takes up the inquiry report, lordship will find just 3 lines, accepts the argument of the PO and holds that all the charges are proved. Now,
This is as per the FCI regulation.
yes. Now, inquiry was held under the FCI regulation.
Is it the same in CCS, CCA?
Almost same CCS, CCA. Certain changes here and there. But if your lordship comes to page number 77 of the writ petition, your lordship will see the inquiry report. 26, in the absence of the defense brief and in consideration of the submissions of PO, as also the documents on record, the undersigned is inclined to agree with the submissions of PO and accordingly it is submitted to the article of charges approved. So, my lord, there is no finding in respect of the charges with reason as required under this particular regulation.
Inquiry officer is from FCI only.
Yes. Now, this is something, if your lordship accepts my first argument, my lord, then the entire inquiry, the appointment of inquiry officer, everything will go. And this is in addition, my lord.
Supposing it goes, then what happens?
Then, my lord, no action can be taken on the basis of an inquiry report, which is not legally.
Can there be de novo inquiry?
If there is a de novo inquiry, then my first round argument, who will conduct the inquiry after my repatriation? Because the rules of FCI is not clear. It does not empower the borrowing authority to go ahead with an inquiry after repatriation of an employee. The rule says that the borrowing authority will have the power to initiate a departmental proceeding. There is no quarrel on that. But the situation, the question will come, once an employee is repatriated, whether the rules empowers the borrowing authority to go ahead and with the inquiry. Now,
But
if
one aspect is there. Whatever incident happened, the alleged incidents that's happened while you were on deputation.
yes.
So on the parent department, there's nothing. Whatever happened, things happened in the borrowing department.
So if there has to be an inquiry, the borrowing department can always send the materials of charges and the reports, whatever it is, to the lending department, and the lending department can go. Now, at the end of the day, what is required? An opportunity of hearing proper to the employee by the disciplinary authority having jurisdiction to take a decision on the matter. Now, here, if the FCI is without jurisdiction, then whatever investigation they have made or whatever documents they have, they could have sent it to the lending department for the lending department to appoint an inquiry officer and go ahead with the inquiry with those cited witnesses. So, not an inquiry by an inquiry officer or a presenting officer from FCI. Now, my lord, now, my lord, another point was referred by my friend about the handbook and all these things. These are instructions based on the CCA rules. Even those handbooks do not confer or do not provide any light as to what will happen to an inquiry after repatriation of the employee from the borrowing department to the lending department. So admittedly, the CCS rules doesn't apply. Now, my lord, my friend has submitted WPC 8305/19. একটা কপি আছে, ওটা বলেছে ওরা বের করবে, দেওয়া আছে। ময়ূর দত্ত। No, my lord, another aspect, my lord. One FCI employee, Mayur Datta, was also charge sheeted. Now, out of these 4 charges alleged against the writ petitioner, 3 were common charges. against him also, although that person, in that case, 13 charges were framed. Now, punishment was imposed, writ petition filed. This is the order of this honorable single judge, wherein this honorable court has found that the allegations, the charges leveled are not clear and distinct, and no inquiry could have been proceeded on the basis of that charge sheet. That judgment went in appeal. Division bench upheld the single judge's judgment. Now,
In the same case, in this case?
yes, same case, same incident.
Another employee.
Another who is a regular employee of FCI.
That has been stated by the Honorable Supreme
Whatever
Court,
it is.
and this is not the pleaded case of the petitioner.
No.
The charges are vague.
No. Even if it is not pleaded, I'm just drawing your lordship's attention to that paragraph 3 of that judgment. Now, in paragraph 3, all the article of charges are quoted. Lordship will see article 3. Why I am referring article 3 of Mohit Datta's case is article 2(1) of the petitioner's case, the same charge. Article 3. And petitioner's charge sheet, your lordship will find at page 37. Article 2(1), fraudulent payment made by so-and-so to Ms. So-and-so for handling bills based on forged work slips. Here, Article 3 pertains to passing of bills based on fictitious slips, work done. Now, lordship may turn to the next page of the judgment. Last 3 lines from the bottom. Article 10 pertain to CC limit enhancement, wherein it is provided that FCI in the district office of so-and-so got its cash credit limit enhanced from 20 lakhs to 70 lakhs in a phased manner. And this is article of charge 2(2), obtaining cash credit limit in favor of party and continue making payment as advance. Then, my lord, next page, article 11. Next page 5. Article 11 pertains to an excess payment of rupees 34.13 lakhs.
Yes. What about this?
Article 11 pertains to excess payment of 34.13 lakhs to the transport contractor. This is article of charge number 3 in respect of the petitioner, which your lordship will find at page 39 of my writ petition.
So what was the conclusion in this case?
In this, and another thing, my lord, article 12 is the article in Mohit Datta's case, that is fraudulent payment of 14.73 lakhs. This is the charge number 4. So far the petitioner is concerned. Same page, paragraph 5, page 5, 8 line from the bottom. And charge, this is the same charge, article charge number 4 for the writ petition. Now, the findings recorded, my lord, it starts from paragraph 31 to 41. And at paragraph 41, from the point of view of the statement of charges and the statement of facts and allegation and so and so memorandum charges, a conclusion can be drawn that in respect of the petitioner Mohit Datta, no specific charge or allegation is discernible, which, if accepted in its face value, may lead to a conclusion that there is a misconduct against him. All the charges and allegations reveal are that certain activities are taken place within FCI in the district of Bandadua, amongst others, where excessive bills were passed in respect of certain contractors, where again no specific information as regards the bill date and the nature of excessive payments are discernible, and such bills were also passed through accounts department, and therefore manager accounts would also be liable for not performing his duty in the requirement. So, my lord, the honorable single judge held that these charges were fake. So, on the basis of these charges, the inquiry conducted was not proper. The matter went to the division bench, and
So where's that finding you just read? Paragraph?
It starts from paragraph 31 and the 31 to 41. Now, paragraph 41 is the conclusion. Paragraph 40, may I read? Similarly, a reading of charges 6 to 13 also does not make it discernible that there had been any specific charge or allegation against the petitioner, and that any such act on the part of the petitioner can be constituted to be a misconduct. Then paragraph 41.
So it was set aside.
Yes.
But then the department was not precluded from
Yes.
proceeding again.
So,
What happened thereafter?
it went in appeal. Honorable division bench upheld the single judge's judgment, my lord. That I have given.
So instead of going for for further inquiry afresh,
Yes,
they went an appeal.
they went on appeal. Honorable single judge's judgment was upheld.
Appeal was upheld.
Then the matter is now pending before the Honorable Supreme Court. So, this is the judgment passed by the division bench. Writ appeal number, my lord, 17 of 23, judgment dated 14 to 25. Here also, charges were held to be big.
So what happens? End of the day, even if they don't succeed in the SLP, that liberty is always there.
Always there. So if as of now, your lordship holds the charges are vague, then in that event also, my lord, whether the finding can any action be taken on the basis of the inquiry report? Number one. And the larger issue is, my lord, whether the very inquiry by FCI is legally permissible.
For that, you give me that
BSF
judgment, any other judgment on that?
BSF and relying on BSF, that Madhya Pradesh High Court judgment.
Madhya Pradesh also. Okay.
Now, my lord, another thing, my lord.
Anything else?
Yes, my lord. Now, the petition, respondent FCI has placed before a lordship the record, and it appears that one written statement against the charge was filed by the writ petitioner on 26/10/2016 in the list of dates which they have given to your lordship. My lord, so far this written reply to the charges is nowhere indicated in the writ petition affidavit filed by FCI in the inquiry report. Nothing, man. And we do not know whether this was placed before the inquiry officer. Now, my lord, we'll see that on 19/12/2017, notice was sent to the petitioner to appear for the inquiry to be held on 29/12/17 and 30/12/17 at serial number 13. First, my lord, this 26/10/2016 written statement by petitioner nowhere indicated in the inquiry report nor in the reply in the affidavit filed by FCI. Now, this is a notice and the petitioner informed that she is on medical leave. On 29/12/17, my lord, one witness was examined. So, on 29/12/2017, there is no order indicating that the inquiry will proceed ex parte for which the witness is examined.
It was informed.
It was informed, my lord. It was informed that if you don't come, it will proceed ex parte. Even then, my lord, to proceed ex parte, there has to be a specific order that we are proceeding ex parte for these reasons. And it is only after the inquiry officer records an order to proceed ex parte, then the witness can be examined, my lord. Number one. Now, after examination of that witness on 29/12/2017, again a notice is sent to her saying that you appear, else it will proceed ex parte. That is notice dated 3/1/2018. That means up to 3/1/2018, the proceeding was not ex parte. Now, if there is no order to that effect that the matter will proceed ex parte, then examination of PW1 on 29/12/2017 is bad, my lord. My lord, in our writ petition at paragraph 22 and 24, we made a categoric statement that we, before submission of reply to the charge sheet, the petitioner prayed for certain documents. By later dated 1/7/2016, before addressed to the director, my lord. Page number 69 is the letter. The CMD FCI for certain documents, and again on 9/8/2017 before the inquiry officer, these two letters, and we have made categoric statement to that effect, and that is not denied by FCI. So it is an admitted position that that the documents prayed for by the writ petitioner was not provided to her. Paragraph 22 and 24. Paragraph 22 is the letter dated 7/9/2016 to CMD for documents, and paragraph 24, letter dated 9/8/2017 to the inquiry officer for documents pointing out the relevancy. But these were not responded and nothing was provided. So 22 and 24 has not been denied by the FCI in their affidavit. Meaning thereby, this is an admitted position that the petitioner, the documents the petitioner wanted to have before giving a reply was not provided to her. Now, my lord, my friend has cited one decision, 1998 7 SCC 84, premature writ petition, my lord. My lord, that judgment is not applicable here, my lord. Now, my lord, in that judgment, before submission of reply and everything, that is a normal disciplinary proceeding where the disciplinary authority from the beginning till imposition of penalty remains the same. In a bank's, it is a bank's case where the disciplinary authority remains the same from the date of initiation of the disciplinary proceeding till the imposition of penalty. Here it is a case where the disciplinary authority is someone and the actual authority for imposition of penalty is somebody else. So that decision is not applicable. To contend that it is premature is, my lord, without any basis. For the reason, my lord, this inquiry report is legally unsustainable, being violative of the rules as well as for want of reasons. So no authority can act upon such faulty inquiry report. And then, my lord, to take it further, if your lordship doesn't interfere, then if they take a decision on the basis of the inquiry report and imposes a penalty, then I have to challenge that order along with that inquiry report twice for the same purpose. What is not legally sustainable will always remain so, even if your lordship interferes at this stage. No authority can act upon such faulty report. Number two, in that 2006 12 SCC, page 28, that again, that is a case where the charge sheet was sought to be quashed, and the Honorable Supreme Court held that it can be done when it is without jurisdiction. Here in my case, my lord, that judgment rather supports my case. I'm questioning the jurisdiction of the FCI authority to initiate and to go ahead with the disciplinary proceeding. So when the jurisdiction is challenged, then our judicial review is permissible, my lord. Scope of judicial review is not to see the decision, but the decision-making process. My lord is well aware, my lord, I need not cite any judgment. When the decision-making process is faulty, starting from the power of the FCI authority to conduct the inquiry after my repatriation and followed by a faulty report, and in between violation of natural justice, documents sought for but not given. So to argue that this is a premature writ, my lord, with all respect, my lord, this is not an argument which can be appreciated. So, my lord, I conclude. Broadly, my lord, my prayer is on the point of jurisdiction of FCI authority to go ahead with the inquiry after my repatriation. And if it is held to be valid, then the next line as to whether the inquiry report is legally valid in the eye of law, because the rules says that it has to be reasoned with specific finding in respect of charges. Here, just 2 lines, except without any reason. Then there is a violation of process of natural justice, because I wanted to have some document. Twice it was not provided. It was, and the fact that I applied for documents and not provided is an admitted position, because paragraph 22 and 24 has not been answered, either denial or acceptance. There is no reply to that. So an affidavit in opposition not replying amounts to admission.
You have not responded to the inquiry report, isn't it?
My lord?
You have not responded
No,
to the inquiry report.
because I am questioning the jurisdiction. Even in this case, when I am questioning the jurisdiction of FCI authority, then, my lord, there is no question. And to respond to the inquiry report, I'll have to respond it to my department, because it is ultimately the authority who will impose the punishment. The law for responding to the inquiry report and to find the flaw of the inquiry is before the disciplinary authority, who will have the power to impose the penalty, not to the disciplinary authority who will just initiate and conduct an inquiry, and then the penalty will be imposed by the lending department. So in that scenario,
Okay.
since
Okay, I'll consider.
Okay, one thing I have for clarification, my learned friend has relied on the Madhya Pradesh High Court decision. In that case, my lord, the petitioner was repatriated on 6/11/1989, and the charge sheet was issued thereafter, 8/5/99. Here in this case, charge sheet was issued thereafter he was repatriated.
but the fact remains,
It will,
my lord, the fact remains whether that after repatriation, you still enjoy the power of a disciplinary authority, in view of the fact that the master-servant relationship comes to an end.
Okay, please write. Heard Mr. S. Chakrabarty, learned counsel for the petitioner. Mr. B.K. Singh, learned standing counsel, FCI. For respondent numbers.
For respondent number 4, 5, 1, 2, and 3.
1 to 4.
1 to 4.
1 to 4, and Mr. M.R. Adhikari.
1 to 4.
Learned government advocate of Arunachal Pradesh for
5, 6, 7, 8.
5, 6, 7.
5, 6, 7.
There's 8 also.
Arunachal Public Service Commission was made a party, but
Hearing concluded, judgment reserved.
Obliged, my lord.
I'm like.
Yes.
Lordship, respondent number 3 have finally affidavit in opposition.
Hmm.
In para 4, the affidavit mentioned that the petitioner has not appeared before any of the departmental promotion committee, sitting held in 2010, 2014, and 2017, as per the office record. So his promotion to the post of senior assistant does not arise. But here any letters. But no any calling letter have been received by the petitioner, and there is no any enclosed.
What is your case otherwise?
Respondent number 5, 6, 7, and 8 have got the promotion. But the petitioner was appointed on 1996 and they were appointed on 2001, 2008.
You are working as what?
Junior assistant.
In the office of the Superintendent of Excise.
Yes, Lord.
Excise. Who are the private,
Superintendent of Excise.
who are the private respondents? 5, 6, 7, 8. Are they represented? You're challenging their promotion.
Yes, Lord.
Where's the promotion order? Where's the promotion order?
Page number 18.
18.
That is the graduation
The
list.
gradation list. Where's the
Yes.
promotion order?
In record, there is no promotion order, but only graduation list is here.
Gradation list itself will not be sufficient.
They were promoted to senior assistant and I am working as a junior assistant.
Gradation list, you are at serial number 26.
Page number 18, Lordship, 1-8.
Yes, I am aware about page number 18.
81-8, Lordship.
Yes, I know that. You are at serial number 26.
26.
Private respondents are above you.
Yes, Lordship.
So what is wrong? They got promotion, they are senior.
They were appointed on 2001, 2008, and I was appointed on 1996.
So are you challenging the gradation list?
Not the graduation list, Lordship, the promotion.
Their promotion. So where is the promotion order?
There is not such a promotion around.
Then-
Graduation list is there.
That means you are challenging the gradation list.
Notification was there regarding graduation list. That is page number 21 and 22.
Who is appearing for the private respondents? No one. You are there for excise,
No, sir, I'm for a state government, Lordship.
state government.
State government, and affidavit opposition filed with respondent number 3, Lordship, yesterday. They filed a affidavit opposition.
Who is respondent number 3?
He is a.
Dhemaji,
Deputy
Deputy-
Commissioner Dhemaji, Lordship,
Additional district.
additional district commissioner.
Additional. Nomenclature says deputy commissioner.
Lordship. He has not challenged the gradation list, Lordship.
No.
Your gradation list, how can we?
Forget about
Challenge the
that at
promotion.
the moment. You said additional deputy commissioner.
Lordship.
Where is additional deputy commissioner?
Respondent number 3 is the district commissioner Dhemaji, Lordship.
No, it's not even district commissioner, it's deputy commissioner.
Deputy, at that time, Lordship, deputy commissioner. Now it is called the district commissioner.
I know, but the nomenclature is same.
Same.
This has not changed.
No.
Page number 3, same.
Lordship, deputy commissioner.
So where is that additional deputy commissioner?
No, no, Commissioner.
Now, why you're saying all these things without there being anything?
So, affidavit filed by the additional deputy commissioner lordship on by authorization. He is a authorized person lordship.
It is not there. Affidavit is not available on record.
Yesterday I filed a opinion of position.
Mr. H. Chakrabarty, learned counsel appearing for respondent number 3 submits that the respondent number 3 has filed affidavit in opposition yesterday. However, the same is not on record. Then what about the private respondents?
They have not appeared.
Notice is served.
Yes.
How, when?
On 9/3/2018, Lordship. Notice was issued. At that time, all the steps have been taken.
Did I say connect to the record? Registry to verify and connect the same to the record. Then these private respondents, this is creating a problem. Office note dated 6/9/2025 indicates that although AD card nor unserved notice has not returned back from the private respondent numbers 6, 7, and 8. How many of them are there? 6, 7, 8.
5, 6, 7, 4, 6, 7.
What about 5? Anyone appearing for 5? But the office note is only regarding 6, 7, 8. Upon tracking the postal consignment, it is found that the item has been delivered to respondent number 6, 7, and 8. Accordingly, notice is accepted to be complete on respondent number 6, 7, and 8. Stop. Now we are stuck with 5. Please the matter again. Give it on 31st. Office to put up a note regarding notice regarding service of notice to respondent number 5 by the next date.
I can fight.
Lordship. Lordship, now this writ petition is for grant of family pension, Lordship. Actually, it was disposed of, Lordship. Keeping in view the conditions laid down in Ujala Nazari and Upenda's case, Lordship. Then we had filed a writ appeal before the Honorable Region Bench, Lordship. In the writ appeal, it was remanded back to the single bench, Lordship. Now, Lordship.
By which order?
By order dated, Lordship. In
What was your writ appeal number?
17, Lordship. Writ appeal of 17 of 26, Lordship.
Okay. Mandrila Basumatri.
Mandrila Basumatri. That is from page number. If Lordship has a copy of the order, Lordship. It is from page 48, paragraph 106, Lordship.
Why was it remanded back?
Lordship.
Why was it remanded back?
Lordship, now, because the
Earlier order was passed on the basis of a judgment Ujala
Ujala
Nazari.
Nazari,
That was subsequently set aside by the division bench. So that is why this matter has been remanded back. Lordship, today I would like to only place one line, Lordship. If Lordship comes to the paragraph 114, Lordship, of the judgment, Lordship.
Yes,
The last page of the.
additional
114,
pleadings,
Lordship.
additional pleadings.
Yes,
You want to file something?
yes.
What do you want to file?
Because earlier it was on the basis of Ujala nursery laws.
Mm.
Now we have some other things. Earlier it was a decided case because Ujala nursery was there. Ujala nursery was placed. Accordingly, case was dismissed.
So on remand, it has come back for the first time.
Yes, Lordship.
Yes.
Oh, okay, you may file. You also want to file something? No.
After he files, I will file a reply, Lordship.
Okay. Parties are represented by the respective counsels and the court is informed that the matter has been remanded back by the division bench. Provide judgment and order dated 29/7/2026. And it has been listed today for the first time after remand. Stop at the outset, Mr. P. Naik, Learned Additional AG, submits that he would like to file an additional affidavit in opposition in terms of the liberty granted by the division bench at paragraph number 114 of the said judgment. Prayer is allowed. Has paid for how much time?
What's the grant us 4 weeks time now?
4 weeks time is granted to file counter affidavit, additional counter affidavit. List again after 4 weeks.
May simply say additional pleadings now, because in the main case also we have not filed any, affidavit now.
Then you say
Pleadings now.
not what pleadings, counter affidavit,
It will be that sort of.
not additional, but counter affidavit. He had not filed anything.
Yes, that is the.
So this will be a counter affidavit then.
Lordship.
You strike out the additional, it will be counter affidavit.
Obliged.
Lordship, I am not on record of the case. Mr. MP Sharma is leading and he is at court number 18. What I am instructed that the petitioner was promoted to the post of assistant engineer in the year of 2013, but he has not received his salary. That is it.
Salary.
Yes, Lordship.
Your case is about salary, area salary.
Yes, Lordship. Salary and allowances, it's conformity of the order bearing number, order dated 23/10/2013.
Barpeta Municipal Board,
Yes, Lordship.
their respondent number
Respondent.
3,
3 and 4.
3 and 4. Who appears for them?
M. Bhattacharya is the advocate of on behalf of the respondent 3 and 4 Lordship, concerned municipality Lordship. I am appearing from the on behalf of the government Lordship.
Which one?
Lordship 1, 2, and 5 Lordship.
Municipal administration.
Yes, Lordship, and additional deputy commissioner.
Have you filed affidavit?
Lordship, we are not the leading party here, Lordship, because Lordship, this is the autonomous body, Lordship, they governed by the Municipal Act, Lordship, and their the employment of.
Okay, so whether the municipal, who is
They
this?
submitted, Lordship. They
Municipal
submitted.
board, they have filed.
Yes, Lordship, they filed.
When?
Lordship,
Recently?
in my Lordship, it is yes, Lordship, it was on 28/7, Lordship, recently, Lordship.
Who is the copy?
Lordship, the deputy, additional deputy commissioner filed on, we filed on 28/7/2026, Lordship.
So the department concerned or the respondent concerned is 3 and 4.
Yes, Lordship.
3 and 4. 3 has filed affidavit,
Yes, it's fine.
but it says additional affidavit. That means earlier there was addition affidavit. Yes, they have filed affidavit earlier also. 13 June 25. Yes, who is the conducting counsel?
Mr. MP Sharma, he is at court number 18, Lordship.
MP Sharma.
MP Sharma.
Is he coming?
He is for item number.
And what about M. Bhachaji? She's not come today.
She is not here. Counsel for respondent number 3.
Please write the conducting counsel for the petitioner and for the respondent numbers 3 and 4 are said to be engaged in a different court. Accordingly, matter stands adjourned. To be listed again on 16/9.
Ultimate.
May please, Lordship. My Lord, this pertains to termination of the contractual employment of the petitioner, my Lord. And without having any reason, my Lord. But there is no response filed till date from the department.
Where is the termination order?
The page number 47, my Lord.
47.
47.
APFBC, what is this?
AFD is a, my Lord, France government financing, my Lord, authority, my Lord. That financed the project, my Lord, where the petitioner was employed as a senior
Assam Project, Forest Biodiversity Conservation Society.
Yes, my Lord, that was financed by that, my Lord, Agency France Development.
You were working as what?
Position was senior procurement specialist, my Lord, he was.
So,
My Lord, this order was an innocuous order, but in fact, my Lord, it was preceded by an FIR laws, my Lord, page number 46. Page number 46 is an FIR, my Lord, regarding procurement of some vehicles, my Lord, for the forest department.
you are named in the FIR?
Yes, my Lord, one of the accused person, my Lord, page number 46. Page number, it starts from, my Lord, page number 44.
Serial number 2.
Yes, serial number 2, my Lord, along with other accused.
Then what has happened to the criminal case?
The criminal case is still no charge sheet has been filed. It is
Okay.
in the investigation stage, my Lord.
Investigation stage.
Yes, my Lord.
Since when?
So it is 16/3/24. And after 3 months, less than 3 months, on 1/6/24, the FIR was lost against all the accused persons regarding anomalies in the. And the allegation is regarding that the person who submitted the bid was not qualified, the company that submitted the bid for supplying the vehicles was not having the qualification or having the experience of supplying the vehicles. But ultimately, the payment is made. There was no allegation of any fraud or anything regarding the vehicles. Ultimately, the bidder was paid all the amount, my Lord. The bidder had approached this honorable court, and during pendency, the amount is paid, and ultimately, my Lord, so, my Lord, since this order is, my Lord, without applying the principle of natural justice, my Lord, at least a show cause notice was there.
My Lord, now perhaps he has
address the court. My lord, need not go to that aspect, man, because the contract is, the service was contractual and it was termination simpliciter, my lord.
There is a application filed by me, that is the respondent number 4, for deletion of my name. Your Lordship, what happened? We are the French Development Agency, Robana. We are the French Development Agency, Your Lordship. We finance the Assam Biodiversity Project for the state of, Forest Department in the state of Assam.
Respondent number?
4.
There is no respondent number 4.
My lord, actually, he doesn't have any role. He was simply implemented because this agency doesn't have any role.
Well, implemented by which order?
May I just place this order of the court?
Oh, just a minute. Ah, there's a amended cost title. Okay.
Yes.
Agents franchise.
Yes, Your Lordship.
This agency has no role, my lord, in his services. Why he was impeded?
What is this?
Your
Because
Lordship, this was the IA which he has filed, and this is the order by which I have been implemented, Your Lordship. Now, this implement was done apparently without giving notice to me and without hearing me, Your Lordship. I have no business to be implemented, Your Lordship. He is nowhere related to me. And I am nowhere related to the entire scheme of the things, except the fact that we are like World Bank. We finance the biodiversity projects, Your Lordship.
my lords, exactly what happens, the first world countries to compensate for.
So now what have you filed?
I filed an application for deletion of my name.
Deletion. What is that? 2240.
Yes, yes, yes.
My lord,
Has it been moved?
Yes, Your Lordship.
Is it coming for the first time?
No, it is still pending, Your Lordship.
Then? Since 25 it's pending. You have not moved it.
my lord, after that,
There
he
were
has
two
filed another
applications
IA,
filed.
my lord, that is the order. Subsequently, another IA was filed.
By?
The same prayer was there, the subsequent IA, my lord. This is the subsequent IA order, my lord.
What subsequent IA?
What the petitioner is trying to bring in, but actually this agency has no role.
No, I've heard that. Don't repeat many times. Now,
This subsequent
that IA for implement allowed, disposed of, impleted.
Yes,
You have filed the, just a minute.
yes, my lord.
You have filed the amended cost title.
Yes.
Now he has filed one IA to strike him out,
Yes, Your Lordship.
but nothing has been, no order has been passed.
No, Your Lordship.
And yet you speak of another IA. What is that?
Another IA, my lord.
Who has filed?
I have
He filed, my lord, because.
For?
Your Lordship,
For?
let me submit, that is my IA. Your Lordship, that IA was for recalling of the order by which I was implemented.
No, why do you have to file two IAs? One is to strike out and one is for recalling.
Recalling, Your Lordship, the recalling was.
Isn't it the same thing?
Yes, Your Lordship.
Recalling means what? Review?
No.
Then?
The recalling was not allowed because the court said that amounts to leaving of the order. So
Ah.
I'll not allow that.
Okay.
Recalling of the
So
order-
disposed of.
Yes, that was disposed.
So now which remains is this one.
Deletion of my.
This one remains.
Yes, Your Lordship.
2240 in
I
fact.
am nowhere related, Your Lordship.
Okay.
Except the case that I have financed the project in the state of Assam.
Okay.
Now, they want to bring a black spot to that, and therefore they have arrayed me as a party respondent only for the sadistic pleasure, Your Lordship. He may have any claims, I have no doubt.
Okay.
He may have any claims with the forest department, but
Okay.
why should he arrest me as a party?
2240 in fact.
What do you say this? What do you say on this IA for striking out?
2240 already infractions, my lord, as per order passed in the subsequent IA, my lord. Kindly see the IA, my
Where
lord.
is the order?
I have submitted the code.
2240 infractors.
Yes, my lord. Subsequent IA, your lordship, I have submitted, my lord. Subsequent IA he has filed, and that is, my lord, rejected, my lord. So it becomes infractions, the earlier IA, my lord. Not maintainable, this honorable court held, my lord. Is subsequent IA for.
The court held
Recalling.
that the recalling of the order is not permissible, so I should approach the appropriate court. But the deletion of name is always there, Your Lordship.
The applicant is as such directed to file an appropriate application before the appropriate court.
Yes, my lord. Then, my lord, he submitted orally before this honorable court that he will file an appeal, my lord, before the division bench, my lord. But till date, no appeal is filed against this order, my lord.
No, that's a different thing. You see, orally submitted and all that. That is something we shall not accept. Now, thing is that this court say that it's not maintainable. You may file appropriate application before the appropriate court.
Yes, my lord.
Now, this order was passed on 11/5/26, correct?
Yes, my lord.
But this IA was already pending that time of 2025.
That IA, dishonorable court, already, my lord, that IA was not accepted, for which a subsequent IA is filed, my lord. And the prayer was same, my lord. Both
No,
the
how
prayer
how
was
do
same.
you interfere with orally not allowed, orally?
My
Oral
lord,
is oral.
For which, my lord, he has filed a subsequent IA, my lord. The same prayer, my lord.
We'll do one thing. This is an IA. It's not disposed of, correct? It's still pending.
Yes, yes.
You file your objection, whatever you have to file.
My
Not
lord,
orally, in writing.
my lord, in the light of the order passed in the 280.
And then we'll consider.
In the light of the order passed in subsequent IA, my lord, this is infractious, my lord.
Mm.
Because the same prayer was there.
You say that by way of an objection.
Obliged.
If you think that
Yes,
it's infractious, we'll consider.
Still the main issue remains untouched.
Mm.
Lordship will take care of him, but as such, my lord, this petitioner also doesn't have any case. I can show, and it's covered case, my lord. I have similar orders.
You have filed your counter affidavit.
No, my
No,
lord,
my lord,
because
2
it
years,
is-
my lord,
No,
already.
no, my lord, because from the initial that we are trying to show that the contract itself speaks, it's a time bound contract, it's over, and I have covered cases.
You also file your affidavit.
My lord,
Oral submission will not do.
my lord.
Parties are represented by the respective councils and they are permitted to file their objections both in the IA as well as in the amended petition. List again on service.
I don't have any objection, so I won't be responding to IA matters.
It's up to you, please.
Obliged.
In this matter, we are being directed to file our affidavit. Affidavit is, in this matter, in this case, Lordship, we are being directed to file our affidavit, Lordship.
Who has directed you?
Water Resource Department was
Okay.
directed to file the
Oh.
detailed affidavit.
Court has directed.
Court has directed.
Okay.
Court has directed to file a detailed affidavit, Lordship.
Hmm.
So we are just preparing. the
Water
affidavit.
Resources
Yes,
Department.
Yes, Lordship.
A verification has to be carried out by them.
Verification.
Whether we have been working in a department or not. Or because this is the third round of litigation we have come
Okay.
before. We are all the, we were the employees under the Water Resources Department as a master code worker.
Okay.
So there was an OM in 1990, 2001, where it said you have worked more than 5 years from 1993, 2001, then your services will be regularized.
Hmm.
That was the case. So we say we fall under that OM.
Hmm.
So there was a chart which was made by the chief engineer. Our name was reflected. Then there was an order passed by this court. The court said that we will not exercise our mind. Let's go before the department and then let the department verify it, whether you have been working or not. Accordingly, my lord, in this round of litigation, my lord, what we are saying that this verification has not been carried out by them.
Okay.
This is our case.
The affidavit is in terms of the order dated 18/6.
Yes.
18/6/26.
So, my lord, let us not let them.
When are you filing it?
Yes, let them take
When are you filing?
it.
Let the matter come up in the first week.
The third time they have taken,
First-
my lord,
Yes,
these are
Lordship.
suffering. my
Because
lord.
it's a voluminous
time.
affidavit. It will be a voluminous affidavit, okay? And the conducting.
No, it will come up on someday, but question is when are you filing?
In the first week of next month, Lordship.
First week you're filing.
Yes, definitely.
First week starts from 1st of September.
Yes, Lordship.
It's a holiday, I think, and 4th is also a holiday. We have 2 days, 2 working days, or 3 working days, including 31st. You have it on 9th?
Lordship.
Can you file by 9th?
9th is, I think it's a Wednesday. So
Yes.
if it is 8th, it is a Tuesday, man. 8th is Tuesday. They can serve the copy in ahead.
Let the matter come up
Advance.
on 10th.
10th.
10th is what?
Thursday.
Thursday.
Okay.
But they have to serve the copy in advance so that
again on that day, the morning they file it again, it will go for 6.
You file it by 8th. Matter will be listed on 10th.
Yes.
What's your good name?
RM Das.
Mr. R.M. Das, Learned Counsel appearing for. Means that the detailed affidavit in terms of the court's order dated 18/6/2026 is under preparation. And he'll be able to file it within another 10 days time. So stop accordingly, the Water Resources Department to file their affidavit on or before 8th of September 2026 with a copy to the other side. Stop list the matter on 10th of September 2026. Mr. D. Das, Learned Senior Counsel, assisted by Mr. K. Mohammed, appears for the petition.
I'm clear. Well, it's that transfer matter. Well, I have come across something.
So what have you decided?
Well, I have come across something.
Why don't you go?
Well, CRPF themselves have adopted this act of 2016 on the DOPT OM, which exempts from routine transfers. Well, I tried to get it, but I didn't get it. But I went through a judgment of Orissa High Court, which
See, Mr. Counsel, thing is that
CRPF.
no. Thing is that you say that instead of me going on transfer, I don't want the promotion. And second thing you say is that instead of going for transfer, I'm ready to resign. You submitted your resignation. Later on, you had a second thought. You said that no, I have so many problems. I'm taking loan. I'm repaying loan. Please recall my acceptance. And in that letter, you say that you're ready to go for transfer. He have bounded himself,
Yes,
saying that you're ready to go. So you go.
No, man, that would be some kind of because that situation has to be my lord, considered in a different manner, because I was suffering some troubles with my mother also, and financial issue also. Nobody's look after. So that situation is a bit different. Now I'm not saying I'm not willing to go, but the instruction they are bringing in that there's no other post they are post, but I have instructions. There are similar battalions are there, that Mahila battalions, and that very DOPT OM, which I'm harping on my lord, 2018, CRPF adopted this,
We cannot go, we cannot, like keep on examining all aspects, explore, examining everything.
Two statutes are there. One is which regulates my transfer. Another is a special statute, my lord, that PWD Act.
Routine transfer and mandatory transfer on promotion is different, my lord. Vast difference.
But if they are promoting me, you are rewarding me. Lordship will kindly come to page number 9 of that judgment.
Yes.
My lord, para 11. The CRPF decides to act on that DOPT OM, which says a government employee who is a caregiver of a dependent daughter, son, parent, spouse, brother, sister with specified disability, with a benchmark disability, to be maybe exempted. They act upon it. And they, no doubt it's a issue of a.
No, there's a distinction. This is not a rotational transfer or a routine transfer. It's a transfer on promotion.
Yes.
Normally, once gets transferred, they don't remain in a station. They normally I think in all cases, they are transferred out to some location.
Well, it's what my humble submission is. Every promotion order need not be accompanied with a transfer order.
It is for them to decide who are we.
This act covering this area, this field.
No.
Central Government Act is there, DOPT notification is there.
Mandatory field service is necessary on promotion, my for further promotion.
Even in the
So much time has flown from the day one. You see, your writ petition dates back to 2025,
25.
1239 of 2025. Court say that, okay, let them consider. They had taken a due consideration. They said, no, there's no merit. You are to go into Mahila Battalion of 232. You go there.
Even then, if we go, that consideration cannot be without any application of mine. My lord, that very is the order which I have assailed, my lord, it doesn't indicate anything. It just repeats narrates the events and says go. That act is there, 2016 act. Definition is there. I have a specific, I'm a caregiver to specify this, my lord, disability. In that case, what the lordship is holding, there was a child. Child had issues, mental issues, my lords. And under the same act, the petitioner was claiming, my lords, and the court interfered.
See, again, this judgment which he was giving me, it's a matter which was remanded back to the authority to decide.
Yes.
Once it was already remanded back, and they have taken a call.
And my lord, the instruction last time
And,
when it is listed, the instruction which they brought, it is something different. Lordship had asked them to specify whether in those specific areas any kind of vacancies or they are not. They come with an answer that it's not possible. They didn't answer the specific query. They just said only you have to go there.
Anyway, we are disposing of the matter.
My lords.
My lord, again, it is the third round of litigation, my lord. First time this honorable court also considered.
Oh, why do you insist on making submission? I'm closing the matter. Don't you get the signal to which direction the court is going? Third, Mr.
D. Gogoi, my lords.
D. Gogoi, learned counsel for the petitioner, and Mr. A.K. Datta, learned CGC, appearing for the respondents. Having regard to the controversy, the matter is taken up for disposal. Stop. The petitioner had earlier approached this court by filing WPC number 2928 of 2024. No. Is this your case?
2928. 2928 of 2024, man.
24?
24, man.
This is the second time or third time?
This is the third round.
Okay. Sorry.
Well, the first time it got
Is it page 26?
but the first instance it was infructuous. Page 35, my lords, first order.
We considered.
35.
35, my lords, first round. In the year 24, my lords, 2928.
So what has happened to this transfer order?
My lord,
19/2/2024.
yes, my lord, that was considered by the and retain her till next summer sale.
Let us interfere, my lord. They cancelled it, my lord. They retained me in the present place of posting for next till the next event when it occasion to me transfer me.
And when is the next transfer which you have challenged?
And then, my lords, I challenge the next transfer order at page 60, my lords. 60, it starts from 61. It was an order of 3125. 31,125.
Earlier transfer was not on promotion.
No.
The first one.
First was a normal transfer.
Okay. What did I say? By filing WPC number 2928 of 2024. Against her transfer order dated 19/2/2024, whereby she was transferred from Gauhati to West Bengal, bracket Mahila Battalion. Stop. However, during the pendency of the writ petition, court was informed that the office memorandum informed that what is the difference in date 19/2/24 and 8/8/24?
Well, perhaps it indicates some sort of order passed by them, whereby that transfer of 19/2/24 was cancelled.
What did I say? The transfer order has been cancelled. And the petitioner has been retained in Gauhati till the summer chain transfer -2025. Stop. Accordingly, the writ petition was disposed of as infructuous. No, you write it. Accordingly, please rewrite again. Accordingly, the writ petition was closed, white order dated 24/1/2025. Stop. Thereafter, the petitioner approached this court again through WPC number 1239 of 2025, and this time against the order dated 31/1/2025, by which she was transferred on promotion to 232 bracket M Battalion, CRPF. Stop. The main ground taken by the petitioner was that her mother is a disabled person and there is no other member in the family available and willing to look after her mother. And therefore, the transfer would be detrimental to the health of our mother. The petitioner had initiated the said writ petition. The writ petition was disposed of white order dated 28/3/2025. By asking the petitioner to file an application before the respondent authority concerned with all particulars, who in turn will examine the same in the light of the Office Memorandum 2/2024, which provided certain exemption for caregiver of person with disability from routine transfer, oblique rotational transfer. The petitioner was directed to submit a representation within a period of 1 week from the date of the order, and the respondent authority concerned to dispose of the same within a period of 3 weeks from the date of receipt of the representation. Until such time, the interim protection granted to the petitioner was to remain operational. Next para. In terms of the aforesaid direction, the petitioner submitted a representation and the respondent authority concerned by order dated 13/5/2025 disposed of the same by rejecting our representation while asking her to proceed to report to the place of posting, place of transfer at the earliest. Stop aggrieved, the petitioner has initiated the instant writ petition. Next, where during the pendency of the instant writ petition, the petitioner on 13/6/2025 submitted an application to the Deputy Inspector General of Police, Group Center, CRPF, Gauhati, requesting the accord of approval for voluntary retirement with effect from 30/9/2025. Of the said application was considered and allowed by office order dated 25/6/2025. it was ordered that the petitioner shall be struck off from the strength of the group center with effect from 30/9/2025. Bracket forenoon. Stop. However, upon reconsidering, the petitioner came to the conclusion that our proceeding on voluntary retirement would not be in the best interest of herself and her mother. And therefore, she submitted an application before the same authority once again on 11/9/2025, seeking the recall of our application for voluntary retirement. While expressing that if her transfer order comes, she would proceed on transfer. To stop, the respondent authorities, upon considering the same, again, upon considering the same, decided to recall or cancel the order by which her application for voluntary retirement was accepted. Stop, the said office order was passed on 23/9/2025. Next, the learned counsel for the petitioner submits that the respondent authorities accept the fact that the DOPT guidelines issued by Office Memorandum dated 8/10/2018 provides certain exemption for government employees who are caregiver of dependent daughter, son, parents, spouse, etc. with special disability certified by the authority competent authority in terms of the benchmark disability as defined under section 2 bracket small r of the Rights of Persons with Disability Act, 2016. Such being the position, the respondent authorities should be directed to reconsider the case of the petitioner since she is the caregiver of a mother who is a disabled person.
Just a moment. Caregiver is also defined under section 2D of the same act.
Stop. He also submits that caregiver is also defined under section 2 bracket small d of the Act of 2016.
That
Stop. It may, however, be seen that. No, before that, he cancelled that. Mr. P.P. Datta, learned CGC, on the other hand, submits that such consideration was already exercised by the respondent authorities, and the petitioner, in fact, had undertaken that she will abide by the transfer order while seeking for withdrawal of her voluntary retirement application. Stop. Therefore, the petitioner cannot have any legitimate grievance under the facts and circumstances. Next para, I have considered the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. The petitioner in WPC number 1239 of 2025 had raised the same grievance about being a caregiver of a disabled mother. And it was under such circumstance that the court had permitted her to submit a representation before the respondent authorities for their consideration in terms of the relevant guidelines in this regard. To stop. Upon such consideration, her application came to be rejected by order dated 13/5/2025. One aspect of the matter which had been highlighted in the impugn rejection order is that the exemption of a caregiver is with regard to routine transfer or rotational transfer subject to administrative constraints. Further, considering the health problems of the petitioner's mother and other administrative constraints, the respondent authority concerned had also observed that proper treatment facility is available in the new place of posting as the (232)(M) battalion of the CRPF is mainly concentrated at Durgapur, West Bengal. Stop. On the other hand, the petitioner has completed 5 years and 10 months in our present place of posting on the day of passing of the impugn order. And therefore, taking into account all these aspects of the matter, our representation came to be rejected. Stop. The same, in the considered view of this court, cannot be termed to be unreasonable, especially when the petitioner herself has also gave an undertaking that she is ready to go on transfer if our application for voluntary retirement is recalled. Stop. Accordingly, upon due consideration, this court does not find that the petitioner can be said to have a legitimate grievance under the facts and circumstances, and accordingly, the petition stands dismissed. By leaving the parties to bear their own cost.
Because today, if the lordship dismisses, they will issue marching orders tomorrow itself. At least some cushion, some period.
A week's time?
2 weeks, my lord.
Why 2 weeks?
Since when the mother is there, I cannot take her as a furniture, my lord. It's a mental issue, mental issue. That much, my lord.
Okay. However, before parting with the records, it is hereby provided that the respondent authorities shall give the petitioner a minimum of 10 days time
10 days.
to proceed to the new place of posting, considering the preparation that may be required and in view of the health of our mother. Remaining, I think, a date will be given. Many of you waited, I don't know, but the time is very limited what to do. Sorry, my lord. This was item 10.